Lordship, it can be taken away two Lordship. My senior Mr. Z Kumar have some personal difficulty. Highly obliged, Lordship.
My pleasure, Lordship. Lordship, prayer for listing for orders, Lordship, criminal revision, criminal petition, Lordship, revision petition, Lordship, and in this case, matrimonial dispute, Lordship, and maintenance is state, Lordship. So, it's some urgency, Lordship. Can it be on 9, Lordship? Obliged.
May it please your Lordship, I beg to mention in criminal appeal for listing, Lordship.
Criminal appeal.
Lordship, appeal has already been admitted, Lordship. There is an IA for bail that may be listed along with appeal on Friday, Lordship, on 12.
Okay.
May I please your Lordship? Lordship, and the matter is the item number 24, Lordship. I take the consent of the other side, Lordship. This matter may kindly be listed second week of February, Lordship.
This item number 24 is along with some other case. Item number 20.
Item number 43, Lordship. Sorry, Lordship. Item number 43, Lordship.
Miss, what is your name?
R. Dekar.
Miss R. Dekar, Lanet Council. You are for?
Petitioner, Lordship.
Miss R. Dekar, Lanet Council for the petitioner, who prays for an adjournment.
This committee, second week of February, Lordship.
She also submits that she has obtained the consent of Lanet Council for the respondent side, who does not opposes the said prayer. Considering the submissions made by Lanet Council, the prayer is allowed. Let this matter be listed on in the second week of February.
Okay. May I please your Lordship, I beg to mention item number 63.
Yes.
That is Brahman, Tuesday or Monday. Tuesday or Monday, let it come.
What is your prayer?
And adjourn this to be.
You want adjournment?
Yes.
What, on what ground?
Actually, personal difficulties.
Heard Miss K. Kalita,
Yes.
Lanet Council for the petitioner, who prays for an adjournment on the ground of personal difficulties. The prayer is allowed. You are on interim?
No.
No. The prayer is allowed. Let this matter be listed in the after 1 week.
Lordship, may I please your Lordship? Lordship, I beg to mention for listing one criminal petition for hearing, Lordship. Last listed on 14/12, Lordship. On the date, due to paucity of time, matter was not reached. May I please pray for listing 191, Lordship. This date.
Hearing it may, because we are not reaching after Bihu.
After we have. So then 19, 18. May I plead your Lordship? I beg to mention item number 36, Lordship. City is not dear, Lordship. The interim may be continued, Lordship.
Item number
36,
36.
Lordship.
Heard Mr.
S. Hawk,
S.
Lordship.
Hawk, Lanet Council for the petitioner. Also heard Mr. K. K. Das, additional public prosecutor, who submits that the case diary is not there and prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed again on
18, Lordship. 19.
19/1. The interim order shall continue till next day.
Lordship.
May it please, my lord. I beg to withdraw item number 20, your lordship.
20.
Yes, your lord. The petitioner has been discharged by the learned trial court.
Heard Mr. S. Day,
Yes, my lord.
Learned Counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application on the ground that the petitioner has already been discharged by the trial.
Yesterday's order.
Considering the submissions made by Learned Counsel for the petitioner, the prayer is allowed. This bail application is accordingly dismissed on withdrawal.
Lordship, most obliged.
May I please the Lordship, I beg to mention one criminal revision petition for listing to come up on 11th January, my lord, for hearing.
May it please your Lordship, I beg to mention for listing of a bail application for withdrawal, Lordship.
When?
On sixth lordship, eighth lordship.
Okay.
Obliged lordship. I have another prayer regarding item number 21 lordship. 21 and 22. Lordship, kindly pass over for the day. And if possible, kindly fix after Bihu lordship.
In 22, charge sheet submitted, Lordship. 22 charge sheet.
22 charge sheets submitted.
Lordship.
So 22 we will take up when it is called.
Lordship.
Lordship.
And 21 on request of learned counsel for the petitioner name, Mr. What is the
A.
name?
Sharma.
A. Sharma. Let this matter be adjourned for today. Let this case be listed after Bihu.
Obliged lordship.
May I please, your Lordship? Lordship, I'm praying, I beg to mention item number 5 for adjournment because my senior counsel is out of the station and I also request to list it on Monday.
Not, Monday may not be,
My lord, it is actually admin matter.
heard, Mr. What is your name?
M. Islam.
Heard Mr. M. Islam, learned counsel for the petitioner who prays for an adjournment on the ground that his senior, who is the conducting counsel of this case, is out of station. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed again on 8th of January.
May I please, your Lordship? Lordship, I beg to mention item number 50, my lord, the last item of the daily list, my lord. The hearing matter, my lord, I've taken the concern, my lord, I'm appearing for the respondent number 1, my lord. My lord, yesterday night, we were being informed by our client, my lord, that we will not be pursuing the matter furthermore, my lord. So they will be engaging new counsels, my lord. So may I pray that this matter may come up after 2 weeks, my lord.
You are for?
I am for the respondent number 1, my lord. The petitioner counsel is here, my lord.
Actually, I appear for the petitioner. Let the matter be listed in the month of February because they said new counsels will be engaged.
Okay, heard Mr.
A. N. Sharma, my lord.
A. N. Sharma, learned counsel for the petitioner who prays for an adjournment. He submits that he has obtained the consent of learned counsel for the petitioner. The prayer is allowed. Let this matter be listed in the month of February.
Actually, there is an interim order.
The interim order shall continue till next week.
Highly obliged.
Obliged, my lord.
May I please, your lordship, item number 2324, lordship. On last occasion, CD was there, lordship. They took time saying that they need some time for go through because it was voluminous. Today it is not there. It may be called for lordship because petitioners are behind the bar since 9/11, lordship. It is there in the office because on last occasion it is reflected in the order also.
Okay, let you
Now we have
see,
to take
see,
office, I have to
you verify it,
I
whether
have to
if it is
verify
in
now.
office, you
23,
let them
24.
see.
Oh, asile last time.
Okay.
all of the time bola.
Okay, so we will look into it.
It may be
We will
taken
look into-
today, lordship. Thank you.
At
At two. Obliged.
May I please, your lordship, item number 54, sub to lordship. Taken up at 2 lordship. Case of the continue after the lordship. Taken up at 2.
I think 54.
54. Oh. Yeah.
Hmm.
May I please, your lordship? For 39 bail application, my lord, offense under section 21C and this succeeded case, kindly call for the LCR, my lord.
Heard Mr.
R. Sharma.
R. Sharma, learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor. This application has been made by the petitioner Mujibur Rahman under section 439 of the Code of Criminal Procedure 1973. And he has been detained behind the bar since 8/6/2023. Since the case has been charge sheeted against the present petitioner, the perusal of the scanned copy of case record of special NDPS case number 59/2023, along with the scanned copy of case diary of Nilam Bazar PS case number 113/2023 would be necessary for consideration of the instant bail application. Hence call for the same. Registry to issue requisition for registry to take steps for issuing requisition for requisitioning the aforesaid scan copies. Let this matter be listed after the date at the on 24th February.
Obliged.
May I please your lordship, item number 2, after some time, my lord, my senior will explain this. Obliged.
May I please, your lordship? My lord, this is for 39 application, my lord. We are behind the bar since 29/12/2023, my lord. FIR is page number 8. What happened, my lord? One Himanshu Bora and Narayan Sarkar demanded ₹4,000 to provide blood. We are not the named accused, my lord. We are Rupjyoti Roy and Niranjan Mondal, my lord. Nothing was delivered, my lord. So far, section 420 or 387 will not come. As because there is no any delivery, my lord. Already the FIR named accused persons
Your
arrested, my lord. We have also been arrested.
Prayer was rejected.
My lord, by CGM Kamrup, my lord.
Where is the rejection order?
My lord, I have not annexed, I have given a statement, my lord.
Only my lord, page 13, forwarding annexed 2, my lord. Ground number 4, the arrested accused person have been frequently doing such type of offense since long. That is the one.
That is the statement of the police, my lord. Nothing delivered. We have not seated anyone, my lord. Only 4,000 demanded by one Himanshu.
Where is on which date it was rejected?
My lord, on the very date of a production, my lord, 30/12/2023. 41A notice should be issued by law. That was not issued by the investigation agency.
Case diary would be required.
Already we are behind the bar, my lord. So,
My lord, there are a group of people doing such activity, my lord. Other earlier also such type of cases came, my lord. This particular case, my lord,
further custodial detention may not be
No,
required.
how,
Regarding-
without perusing case diary, how we,
my lord, yes, my lord, regarding this particular case, whether there, my lord, involvement
Actually,
or
my lord,
what is their involvement?
so far as the forwarding report of the corrective persons, those persons can
no,
to donate blood.
case diary would be
My-
required.
My lord, kindly file verification.
Third,
Dada.
Mr. A. Paramanik, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned counsel for the prosecutor.
10 on, my lord, should be.
Considering the allegations made in the FIR, perusal of the case diary would be necessary, hence call for the case diary, fixing 10/1 for case diary.
Highly obliged.
May I please your lordships? The 439 application lordships, the NDPS case lordship, today's 43 days lordship. Recovery only 7.99 gram lordship, today's 43 days lordship. Length of detention lordship.
Case diary.
Manikpur,
Heard
Before vacation.
heard Mr.
N. Ahmed.
N. Ahmed, learned counsel for the
12,
petitioner.
12.
Also heard Mr. K.K. Parashar. Call for the case diary. Fix
12 one.
12/1 for case diary.
Yeah. 439 application.
11
lordship.
days.
Today is about lordship
11.
1 year ago lordship.
Uh-huh.
Till date no charge sheet is submitted lordship.
Oh,
Is behind the
22
ball.
na? Oh,
21A and 29 of NDPS. lordship.
1 year.
1 year, about 20.
Why your prayer was rejected by the trial court?
Alcohol was rejected lordship.
Where is the rejection order?
Rejection order is not available lordship. Rejection order is not.
Then we have to peruse the case diary. We don't know. You have to furnish the rejection order also. Because 21A, why you are detained behind the bar so long if it is only 21A? You have to give all facts before the courts.
Lordship.
not of, Pandit of Kumikuran.
What was the contraband? Okay. This is a,
Three point
this
one
is
two
a charge sheeted case.
no, Lordship. Till that no such thing. 3.12 gram, Lordship. Addict person, Lordship.
Then why the trial court rejected the bail, your bail, on what ground?
Order is not available. Lordship.
Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Call for the case diary. Fixing, where,
My lord, from Bokhisto,
9.
11, my lord.
fixing 11, 1. Fix it on 9,
9, my lord. Okay.
fixing 9,
Nine.
1 for case diary.
My lord.
Diploma.
Please, your lordship, 439 application, lordship. Petitioner was arrested on 2/12/2023, lordship. Today is about 34 days, lordship.
What was the seizure? Case diary, we have to peruse the case.
Lordship, it's a registered under 21B, lordship. 60 days is mandatory, for 34 days they are then the bar, lordship. FIR is at
What was seized?
only 8.22 gram heroin, lordship, suspected to be heroin, lordship. And lordship granted bail to the co-accused who is named in the FIR, lordship. It is at page 18, lordship. At the motion stage, lordship.
আমি বুঝিনি
আমি তো আমি তিনজন কিশোরী এইটা জনি চৌধুরী সাহিল হোসেন শাহনওয়াজ lordship granted bail to this accused person who is named in the FIR and forwarded on the same day, lordship. As per seizure, lordship, 8.22 gram suspected to be heroin recovered, lordship, from the vehicle, lordship.
What is your name?
My name is Joni Chaudhary, Sahil Hussain and Sanawaz, lordship. FIR is at page 11, lordship. Lordship, main content will be
The perusal of the case diary would be necessary. The co-accused was granted bail because his name was only revealed by the co-accused.
but as per
His-
FIR, last paragraph of the page number 11, lordship. May I read, lordship?
No, let us fix a short date and call for the case.
Yes, please.
We are fixing a short date before.
Lordship. It's from Soigao, lordship.
Heard Miss S. Nargis, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Considering the allegations leveled in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary, fixing 11, 10-1 for case diary.
Obliged, lord. And in this case, there is no bar of this 37, lordship. Obliged.
দাদা 3-2 non-APS for the petition order.
In this case, my lord, perhaps case diary was called for.
Case diary is there.
My lord, not received. My lord, we send messages. I may be given some time, my lord, so.
Okay, for case diary or scan copy of the case diary? Case diary. Earlier scan copy of the case diary was called for.
Yes, my lord.
It is a charge
No.
sheet.
Charge case. Well, charge is not.
No, not charge. sheet.
Not charge.
None appears for the petitioner on call. Mr. D. Das, learned counsel, learned additional public prosecutor, prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed
On 9th of February.
on 9th of February for case.
Item 6.
Lordship, the matter may be taken after some time, Lordship. So Imbora is coming, Lordship, on legs, Lordship, after some time. Item number 6.
Item 7.
May I please the lordship? Lordship, in this case, the petitioner is a dentist, doctor, my lord, and his ex-wife filed this FIR, my lord. My lord, it is alleged that while they were living as husband and wife, then the petitioner, this doctor, my lord, taken a car loan, my lord. An allegation is that he has forged her document and signature, my lord. My lord, actually, what happened, my lord? Lordship will find the FIR at page 13, my lord. Relevant question. Actually, what happened, my lord? While the petitioner was living as husband and wife in Tinsukia, my lord, he has taken a car loan, my lord, from ICICI Bank, Tinsukia branch, my lord. Thereafter, my lord, the petitioner fallen serious illness, my lord. This is blood cancer, my lord. Thereafter, this wife filed a divorce petition and get separated from her, from him, my lord. Thereafter, in the year 2023, my lord, the marriage was taken place in the year 2016, my lord, and car loan was taken 31st August of 2018, my lord. And in 2019, January, the blood cancer was detected on this petitioner, my lord. Thereafter, she got separated from him, my lord, on March 2019, my lord. And finally, she filed a divorce petition in the year 2020, and divorce was granted by the order dated 6/10/2021, my lord. I have annexed the order, my lord. Thereafter, 2023, my lord, she has filed this FIR stating that while he was living in Tinsukia, my lord, by forging her document and signature, he has taken the car loan, my lord. And therefore, the allegation is that therefore her civil score was come down, my lord. Lord, everything is on record, my lord, documentary, my lord. So the petition may be granted in the secretary, my lord. Custodial interrogation may not be required, my lord.
Yes, yes.
After 5 years, let them be called in the meantime.
When the affair was
FIR
was lodged on, my lord,
20.
14/6/2023, my lord.
Heard Mr. B. Chandra, learned counsel for the petitioner. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Dr. Ratul Das, who is apprehending his arrest in connection with Tinsukia PS case number 383/2023 under section 120B/468/471 of the Indian Penal Code. The gist of accusation in this case is that on 14/6/2023, one Pinky Sen had lodged an FIR before the officer in charge of Hojai Police Station, inter alia, alleging that the present petitioner, who is the ex-husband of the first informant and who got separated in the year 2018, took a car loan from ICICI Bank Tinsukia branch by forging the signature of the first informant. Stop. Whether the allegations are true?
No, madam.
Stop. Learned counsel for the petitioner has submitted that the first informant was the wife of the present petitioner, and after the present petitioner got detected with blood cancer,
My lord.
the first informant filed a divorce case against him and ultimately in the year when the divorce was
6/10/2021, my lord.
in the year 6/10/2021, the divorce was granted.
My lord.
It is also submitted by learned counsel for the petitioner that though the alleged incident, the incident alleged in the offense is of the year 2018. However, the FIR has been lodged in the year 2023.
My lord.
It is also submitted by learned counsel for the petitioner that the allegations made against the present petitioner in the FIR are not true. And considering the allegations made in the FIR, custodial detention may not be necessary. It is further submitted that the petitioner would cooperate, petitioner shall cooperate in the investigation if he is allowed to go on bail. Learned additional, disposing it off. Learned additional public prosecutor has submitted that considering the fact that the allegation is of forgery which occurred in the year 2018 and considering the fact that the matter relates to documentary evidence only, custodial detention may not be necessary. Hence, stop. Considering the submissions made by learned counsel for both the parties and materials available on record, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial detention may not be necessary for fair completion of the investigation of Tinsukia PS case number 383/23. Stop. In view of above, the petitioner, namely Dr. Ratul Das, is hereby directed to appear before the investigating officer of Tinsukia PS case number 383/2023 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Tinsukia PS case number 383/23, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. Borman condition Duta sign. With above observation, this bail application is hereby disposed of.
My lord.
May I please allow? First, application for the quashing of the charge sheet and the order of framing charge, my lord. In this case, what happened, the allegation against the petitioner, who happens to be the executive engineer of the agricultural department during that period in Patsala. The allegation in the FIR basically that he has withdrawn money through his shelf checks, which is prohibited by some of the agricultural circular. That is the allegation by the informant, madam. Then thereafter, the charge sheet has been laid down after the investigation, my lord, and the witnesses has been examined also.
Witnesses, trial is
Sorry,
proceeding.
madam, 161 statement.
Okay.
During the investigation, madam. So in the charge sheet, my lord, there is no reference regarding why the sanction is not taken by the investigating authority, whether they have sought for the sanction or why the sanction was not even sought for. To that effect, there is no indication in the charge sheet. Thereafter, my lord, when the court matter has come to the court, my lord, during the charge, we have also argued the matter before the learned trial court. Lordship kindly see page 43. This is the application we have moved, paragraph 7. we have taken the ground of that the no sanction has been taken under 197, which is required because the allegation that he has violated the office circular, which is in discharge of his official duty.
What was the allegation?
Allegation is that he used to withdraw the money through the shelf checks and has distributed to the beneficiaries. And the shelf withdrawal of the shelf check is prohibited by any circular.
Okay.
So basically, that is the violation he has committed, that is the allegation. But though the 161 states, I can place the before your lordship, that there is no allegation to that effect, there is no allegation of the misappropriation, rather it is stated that is the prevailing going on that procedure and that is allowed also there is to that effect. The witnesses has rather testified in favor of the petitioner, my lord. Whereas the impugn order also, my lord, though we have challenged that the order of taking cognizance during the discharge, that the cognizance is bad because without the sanction against the public servant, with that allegation, the sanction is necessary. There's no mention about in the charge sheet regarding the procurement of the sanction. Neither the trial court has not given any reason why sanction is not necessary in this case. Absolutely silent while the framing of charge, in spite of our argument to that effect. My lord, 43 is the written submission we have made before the court. Paragraph 7. Now, page 54, lordship can turn into, that is the impugn order.
Yes.
Impugn order.
Yes.
This petition under so-and-so has been filed by the accused to so-and-so, accused underway to involve the allegation of the instant case. Therefore, he may be discharged from the offences of this case. Has been stated in the petition that during the relevant period, the said government scheme under the Agriculture Department, there is no provisions of the payment of wages through the bank transfer to the laborers and the suppliers. Hence, no question of the misappropriation of the government money by way of the cash with money by way of cost withdrawn, though the self-check has been accused person arises. That apart, it has also been stated that the implementation of the said schemes were governed by the guidelines issued by the Director of Agriculture, and the accused has carried out the project work without violating the such guidelines. In view of the above, the contention of the petitioner accused player is examined from this case. Heard both sides, so-and-so, Perez DCR as well as CD. In my considered opinion, the accused Patul Sabha cannot be given the benefit of exemption of prima facie sufficient ground are available against him. Exemption of the accused at this stage may hamper the proper adjudication of the trial of this case. That is the framing of charge order. In this order, my lord, there is absolutely trial court is silent regarding the sanction part. In the charge sheet also, though we have categorically made a statement that
By this order, charges were not framed.
charges is framed.
Mhm.
No, 211
Accused
for CC.
finding sufficient grounds against him.
But no charges were framed.
No, he has already made up mind, my lord. Prima cannot be given benefit of exemption as prima facie sufficient ground are available against him.
He has made an observation that I am inclined
Next
to
order, my lord, 211, my lord, next page, my lord,
On ne-
56.
on next date.
On next date, see, search. Next one. Today is for CC.
On next date, charges were framed.
Yes. So this is the observation, so the charge has been framed without considering the 197, which is required because the violation absolutely connected in the charge of official duty. Lordship also can see the order that just I'm playing the page 27. Page 27. Just though it's not a mandatory for the lordship to comply with, but just a persuasive observation, my dear.
Page 27.
27.
Yes.
By going to the MR and all the no. What is divided? Hold on.
Yes, what is page 27?
27 is the observation by this honorable court while granting bail. After going through the entire record, my lord. During the course of investigation, my lord.
No, your ground is that sanction ought to have been taken.
Yes, either they would have said that the no sanction is required, or they could have waited for sanctions. Charge sheet is absolutely silent. Why the sanction was not sought
You
for?
have taken the plea that sanction is necessary,
Yes, that is what I am submitting, my lord.
and
That
that,
is the
that
page-
was not considered by the trial court.
absolutely silent, absolutely silent. Page 43, or that's why you have filed a written argument before the trial court that the sanction is required. Page 43, paragraph 7. The trial court is absolutely silent whether the sanction is required or not required, whether it's been doing. This is basic, my lord. When we have pleaded for sanctions, either it has to be rejected that the no sanction is not required. That is the reasonable expectation from the trial court, my lord, while the framing of charge on the point of sanction.
409.
You are praying for quashing of the
I'm praying against the framing of charge.
framing of charges. Yes,
But at this stage, Malad, of course, Malad, at the time of bail, Malad, that CD was produced by that honorable court, Malad, but subsequently submitted. So, Malad, there may be further Malad, development in the case, Malad. So, scan copy of the
no,
CD.
where is the allegation, FIR?
FIR lordship will find
And,
as page
and in
24.
the charge sheet, what is the finding?
No finding, my lord. Charge sheet absolutely silent, how the misappropriation or anything. Nothing. Only simply they say mechanical charge sheet. It's a copy paste of the FIR,
Where is the FIR?
FIR page 24. Very plus.
No, the gist of FIR is,
Page 24, my lord.
yes, you
That
may,
is the main, my lord, is just in.
please read it.
Yes, I have honor to inform that I have been repeatedly and verbally by official letter requesting the Assistant Executive Engineer Pathshala to submit the beneficiary list of all the machineries with effect from 2010 till date distributed from the office of the Assistant Executive Engineer Pathshala, but the Assistant Executive Engineer Agriculture Pathshala has not submitted the above document till date.
You are the assistant executive engineer.
Yes.
Okay.
But the Assistant Executive Engineer Pathshala has not submitted the above document till date. The Assistant Executive Engineer Agriculture Pathshala as well as the Head Assistant and the cashiers of the establishment do not even receive my phone call. Till today, I have not been able to get the beneficiary list, but somehow I have collected the current account number and I have been able to get the bank statement. I have sent office staff to get the beneficiary list, but even then, they also were not rebuffed and denied. The facts has been reflected from the bank statement as follows. The Assistant Executive Engineer Agricultural Pathshala has withdrawn cash from the current account number so-and-so, signs check as self. The list of checks are enclosed as Annexure A. It is now apparent that the Executive Engineer Agriculture misused the DDO of the power to withdraw the cash by check signed by the self from the office of the current account. If transpires from the circumstances and the evidence that he misused the financial power with an intention to misappropriate the government money drawn by him to public interest, it may be mentioned that both of them with the common intention in the condiv edition have not entered the withdrawals as self in the cash book fraudulent to avoid exposure to the audit about the drawing of money as a sale from the current account, which is criminal and offences as per the financial rule of Assam, which indicate the misappropriation of the government money for personal interest. That is the allegation, madam. So basically allegation that he has violated the office memorandum, he has withdrawn money from the account, current account by issuing self-check.
Okay, yes.
Regarding misappropriation of government money, so at this stage, the scan copy of the CD is required, though in the charge sheet, not elaborately discussed, but witness we have to,
Madam, I have. Lordship, kindly see my petition, my lord, page 42. I have given all the statement in my petition, my lord, page 45 onwards. All the statement elaborately I have from 161 statement. These are the 161 statement, my lord. First PW1. Apart from the allegations of the informant as level in the FIR, she has stated as per the government memo, DDO has no power to withdraw money through self-check. An instant case accused petitioner has withdrawn money to the effect of 50 lakhs 30,662 rupees through 49 numbers of checks from 28/1/2010 to 28/3/2014 and thereby misappropriated said money. She has further stated that she has informed the same to the Chief Engineer Agriculture and Khanapara, Guwahati to take action. Now PW2, this Said Salim Haq, Junior Engineer. He stated that he was aware
Okay,
of
no, your plea is that sanction ought to have been taken. That is
sanction ought to
your,
be taken first of all.
And no evidence.
And to that effect, regarding the statement of all the 161 statement, not a whisper against me that there is a misappropriation of fund. Rather, they have in favor of the petitioner. There is no allegation of the misappropriation. Rather, the money has been distributed. Rather, one of the witnesses rather say, Lordship, kindly see space 48. Junior engineer, there are beneficiaries also, they have been examined. They have received the money, they have received all the machineries from the department. Now, page 48, that Basubdev Talukdar, my lord, has your lordship got it, my lord.
yes.
Basubdev Talukdar. He was working in the office of the State Executive Engineer Pathshala as a Junior Assistant Executive Pathshala. He stated that the beneficiaries are selected as per the guideline of the scheme as after depositing the farmer's shares, machines are distributed as per the department rule. He further stated that the procedure and the implementation of the scheme. He also stated that the 2010-11 land development projects were implemented through which continued till 2013 as per guideline. The work were done. The construction committee is constituted to who monitors the work. As per the master of labor or through the daily workers, the work were done. Payments were made through the JE to the workers. JE makes the application to the Assistant Executive Engineer for release of the funds, and upon the application, Assistant Executive Engineer receive money from the bank through accountant, and the JE makes the payment to the workers through the master roll. So that was the prevailing procedure. He further stated that in the year 2010 to 13, there was no rule and procedure to make payment
Okay,
to the
we are
bank.
issuing notice.
And in the meantime, my lord, the further proceeding against me may be started.
Mr. A.M. Bora, learned senior counsel assisted by Mr. D. Talukdar, learned counsel. D. Gogoi, learned counsel for the petitioner. Also heard Mr. K. Parashar. This application under section 482 read with section 397/401 of the Code of Criminal Procedure has been filed by the petitioner Shri Pratul Sharma impugning the order dated 9/10/2023 and 2/11/2023 passed by London Chief Judicial Magistrate Bojali, Bojali Pathshala in PMP case number 221/2021, whereby charges under section
420, 409.
slash 409 slash 468 slash 471 slash 34 IPC were framed against the present petitioner. The gist of acquisition is that, in this case, is that on 9/10/2017, the executive engineer within bracket agriculture Nalbari division Nalbari lodged an FIR before the sub-divisional police officer Patshala, inter alia alleging that the assistant executive engineer within bracket agri Patshala, that is the present petitioner, while he was acting as drawing and disbursing officer, misused his powers as DDO to withdraw the cash to be disbursed amongst the beneficiaries by check signed as self from the office current account. Stop. It is also alleged that the petitioner had misused his financial powers with an intention to misappropriate the government money drawn by him for public interest. Stop. On receipt of the said FIR, Patasar Kusi PS case number 714/17 was registered and investigation was initiated. Ultimately, on completion of the investigation, charge sheet was laid. There are only you are the accused.
No, two.
There's one more accused.
Charge sheet was laid against the present petitioner and
Here it
one
is.
more accused under section. Charge sheet was laid under section
Same, my lord.
under section 420/406/409/468/478 plus 34 IPC. And thereafter, by the impugn order, charges were framed against the present petitioner. Learned senior counsel for the petitioner has submitted that in the charge sheet, that during the investigation, the investigating officer recorded the statement of witnesses under section 161, and none of the witnesses have implicated the present petitioner for misappropriating the government fund. The only allegation against him is that he violated the office memorandum by withdrawing the money, government money, by self-drawn check. Learned senior counsel for the petitioner has also submitted that in the instant case, the petitioner had conducted his official duty, and the offense alleged against him is alleged to have occurred in the course of his official duty. However, no sanction under section 197 was obtained. Learned senior counsel for the petitioner has also submitted that this plea of not taking sanction under section 197 of the CRPC was taken before the learned trial court at the time of consideration of charges. However, learned trial court has not mentioned in the order by which charges are framed anything regarding the plea taken by the petitioner regarding requirement of sanction. So, learned counsel for the petitioner, senior counsel for the petitioner has submitted that neither the neither there is any mention as to why sanction was not required in this case, nor the plea of the petitioner as regarding requirement of sanction was considered by the learned trial court while framing charges. Hence, the order of framing charges against the petitioner is bad in law and required to be interfered with by this court. On the other hand, learned additional public prosecutor has submitted that perusal of the scan copy of the case record of PRC case number 221/21 would be necessary in the instant case. Who is respondent number 2?
That informant, my lord.
Informant, police person.
Mosami Das.
Notice will go to her. Stop. Issue notice to the respondent number 2. Issue notice to the respondents. As learned additional public prosecutor has received notice on behalf of respondent number 1, no formal notice need to be issued. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. Let this scan copy of the PRC case number 221/21 be also called for from the trial court. In the meanwhile, considering the fact that apparently it appears that the alleged offense, the offense alleged against the petitioner has been committed in course of discharge of his official duty and no sanction was obtained by the prosecution side, and neither the plea of the requirement of sanction was considered by the learned trial court while framing charges. Hence, till further order from this court, the further proceeding of PRC case number 221/21 is kept in abeyance. Let this case be listed after 4 weeks.
Obliged.
Page 10 is there, Your Lordship. Merit.
What is the offense?
Lordship, this is registered under section 294, 353, 379, 506, redo section 135 of Electricity Act. The page 10 is there for merit.
Yes.
With reference to the subject cited above, I have the honor to inform you that on 2012-2023, myself along with Sri Shahinur Islam, SMR and Riazul Islam Shohayak and other sub-divisional staff APDCL were conducting an anti-theft cum disconnection drive operation at Patakata village. During the operation, we have found an unauthorized electricity connection at the premises of Mirazul Haq, this is the present petitioner, son of late Sofiul Haq at village Patakata, Post Office South Somara, PS South Somara, District South Somara, Mankasar. He misbehaved and verbally abused our line staff, namely Riazul Islam and other staff, while they were performing job duty, that is disconnection cum anti-theft drive on 2012. Also from the FIR, there is no ingredients of section 353.
No ingredient of?
Section 353. Because he verbally abused, Lordship.
Okay.
And so far as Lordship 135 of Electricity Act, Lordship, I have annexed the electricity bill, also the bill payment receipt. Lordship, kindly protect him and
Where is the bill payment receipt?
yes, Lordship, page 13. Bill payment receipt is Lordship page 15.
Page?
15, last page.
No, but unauthorized electricity connection.
No, Lordship, he is the authorized electric connection. He, Lordship, because Lordship, he is the husband of the GP president, Lordship. Because the line staff went that village and disconnected some of the connection of the poor peoples. He being the husband of the GP president, he verbally asked the officials not to cut
No,
it.
your connection is unauthorized.
No, Lordship, my connection.
Where is your consumer number?
Yes, Lordship. Page 13, Lordship.
Page 13.
Yes, Lordship. This is type copy, Lordship.
Where is your consumer number?
Lordship, reference number, this is Lordship.
It says that no consumer number.
No, Lordship. Non-existing, no, Lordship.
My lord, this
You have repaid,
5,000 something rupees has been,
you have paid the money.
Yes.
meter number non-existing.
No, Lordship, there is no meter. It is the duty of the FEDCL to provide meter. Some more electricity, Lordship, in the village area that is
So-
going on without meter, Lordship. Lordship, the bill itself, Lordship, it is not my return, it is the official, Lordship.
Official bill, my lord. Maybe this huge amount of bill 5,600 in a village area, my lord. With my lord penalty, this money has been taken. Maybe, my lord. Bill is not enough. And stealing electricity, my lord, dangerous for them also, my lord.
If his connection is unauthorized, Lordship, how the electricity, he paid the bill, Lordship, they were taken bill, Lordship.
No, this plea is not very convincing
No, otherwise,
because
Lordship,
your
yes, Lordship,
bill is of 48,384.
Yes, my lord, this is
yes,
You have
Maybe
paid only
penalty.
5,000 rupees.
yes, Lordship, Lordship, what partly Lordship paid.
This, your,
this has to be penalty, my lord. Otherwise, 48,000 bill in a village area, in a resident, my lord, domestic.
No, Lordship.
Category is domestic.
In the bill, Lordship, last 15, Lordship, due amount, Lordship, has 5,694 rupees, Lordship. Payment mode, bill amount so and so, receipt, payment date 23/12/2023.
will go through the case diary.
Lordship, since the section 353 is Lordship concerned, there is only verbally abusing them. And otherwise, there is 135 Lordship Electricity Act, Lordship, punishment is 3 years. Considering Lordship, let him, his statement will be recorded and produce all relevant documents, Lordship.
Yes, Mr.
My lord, at least the CD may be called for and another thing, my lord, in the first page, my lord, these costable, the sections are also, my lord, wrong. 147, 148, 325, 326, all these, my lord. In the first page, costable. No? At least the CD may be called for, my lord, regarding this,
No, yes,
I have
what
doubt,
is
my lord.
this in the cost title?
Costable, my lord, I have 326, how it is come, my lord.
You have to correct it.
Lordship, I will file IA for correction. Lordship, in the meantime, Lordship, anything else?
No, you will not get a relief on the basis of defective petition. You have to, you make amendment in your petitions.
Lordship, I will, for cost center, I will make IA for correction of the amendment.
Learned heard Mr. L.R. Majid,
Is it all?
A.Z.
Ahmed.
Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned counsel for the petitioner submits that he may be allowed to file an interlocutory application for correcting the cause title of the and the instant anticipatory bail application as some typographical error has crept in the said
Then also day after tomorrow.
application.
No,
The prayer is allowed. The petitioner may file the interlocutory application as prayed for amending the cause title. and thereafter this case be listed again on 8th of January. You have to, you correct it, then we will consider.
Please, Your Lordship. People would find the FIR on page 12, Your Lordship. Your Lordship, the petitioners are implicated under section 379. If I can say, Your Lordship. Actually, what happened, Your Lordship? May I read out the FIR, Your Lordship?
Yes.
Page 12 is the translated copy. It is respectfully submitted that I am a police personnel of Dorong. At present, I am posted at Doipam Police Outpost. On last 24/12/2023, I was entrusted for night patrolling duty along with AV armed staff under Doipam Police Outpost. While I was, along with staff, went out for area patrolling duty, we were conducting area patrolling. Then at about 2:30 a.m., while we were patrolling at Duliapara Gaon, we found one Baleno car without number plate and two motorcycles along with 4 or 5 people were waiting in front of the house of Muhammad Monowar Ali, son of Muhammad Kitab Ali of village Duliapara. Then we got down from the patrolling vehicle, and after observing us, those people fled away from the place. Then we charged the Baleno car and found 2 number of Muga colored cows. On suspicion of being stolen cows, we immediately informed the IC of Doipam Police Outpost over phone. Then he immediately came to the place of occurrence and took necessary steps for investigation. During the course of investigation, we found the involvement of the below named accused person in connection with cow theft, and hence prayed to kindly take necessary action against them. Now, Your Lordship will receive the name and address of the accused. The number 1 and number 2 accused, Your Lordship. They are from Dorong district, and number 2 is my driver. Number 3 is the owner of the Baleno car, and number 4 is my cousin, Your Lordship. Now, Your Lordship, I have bought a brand new Baleno car, Your Lordship. Till now, I have not got a registration number. Your Lordship, I have not bought a Baleno car for theft of cow. My driver took out the car, and if he has done something, Your Lordship, I am not aware of, Your Lordship. Now, I have been implicated in this effort just because the car belongs to me, Your Lordship.
You are named in the FIR.
Yes, Your Lordship. The number 31, Muhammad Mutabali Ali, vehicle owner, Tesh. But they are from Teshpur, Your Lordship. And number 4 is also from Teshpur, the cousin. So, Your Lordship, just because they are the owner of the car, Your Lordship, their name got implicated, Your Lordship.
Case diary would be required.
At 2:30 a.m. Malad in Baleno car, 2 cow.
That too a brand new car.
Yes, Your Lordship.
They are looking.
But case diary would be required. Heard Mr. I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Considering the nature of allegation leveled against the present petitioner in the FIR, the result of the case diary would be necessary. Hence, call for the case diary fixing
On 11th, Your Lordship. From
on 11th, 1 for case diary.
Meet please, Your Lordship. This is the petition for quashing of a complaint and the order taking cognizance also. Lordship, I bought one Tata truck from the opposite party number 2, Lordship, by executing one agreement for sale. That is on page number 16, Annexure 1. As per the agreement, Lordship, since the truck was hypothecated to a finance company, apart from the consideration amount, I have to pay the remaining EMIs. That was one of the clauses of the agreement. Subsequently, Lordship, after completion of a sale, so I used to run my truck, and sometimes I also give it on rent also. So one third party, his name is Anuj Singh. He took my truck on hire for some delivering some goods from Guwahati to Manipur. Accordingly, he took the truck to Manipur. But when the truck reached Manipur, I was informed over telephone that some miscreants forcefully restrained the truck and demanded money. on refusal to pay money by the driver, they forcefully kept the truck also. That was informed over to me. Subsequently, that third party, Anu Singh, he said that I somehow brought the truck from Manipur to Guwahati. And he informed me, Anu Singh informed over telephone to me that now you have to pay 1.7 lakhs to me, then only I will return the truck to you. But I agreed to pay the amount because he was not giving back my truck. But he's not giving me back my truck. So to that effect, I have filed a complaint before the learned CGM Gulahaghat against the Anu Singh for misappropriation of my truck. That complaint is, Lordship, on page number 20, Annexure 2. I am Riku Ahmed and accuses Anu Singh who took my truck to Manipur and now he is misappropriated. Subsequently, learned court below directed the officer in charge of Golaghat police station to register a case and to investigate into the matter. That order is, I have annexed it on page number 31, Annexure 3. Page number 31, Annexure 3. On my complaint, this was the order passed by the learned court below to register a case and investigate. And since for many months, the truck is with that Anu Singh. So during that period, I defaulted the payment of EMIs. Now let's say the original owner from whom I bought the truck by executing the agreement, he filed a complaint before me against me before the learned court of CJM Amingaon, Guwahati. That is, I'm for passing of that complaint also. That is on page number 32, Annexure 4. The only allegation is that I am not paying the EMIs. That is why I am committing the offense. This is the 30. The original I have filed because I am defaulting in payment of EMIs. That's it. Since now I am only because of I am not able to run my truck because of the misappropriation. For that I filed a case also. Non-payment of EMI doesn't amount to criminal breach of trust. Charge is framed under section 406. Let's say for constituent offense under section 406, there has to be two ingredients. As per section 405 of IPC, there has to be some entrustment and subsequent dishonest misappropriation.
The truck has been entrusted to you.
It was sold to me. It was
No,
sold
it was
to me.
not sold. There was an agreement to sell. And
It was.
there is no sale. There was an agreement to sell and therefore thereafter truck was handed over to you
Yes, handed over.
with certain stipulations.
Stipulation. I would like to rely on clause number 11 of the agreement, Lordship. That is on page number 18, Lordship. Page number 18. It is clearly stated that if I fail to pay the EMIs, then the finance company will be at liberty to take possession of the vehicle. May I read, Lordship, page clause number 11. That after signing this agreement, the first party has no liability to repay the EMI towards the financer, and same shall be borne by the second party. If the second party fails to pay the EMIs, the financer take over the possession of the vehicle in that case, and the first party has every right to settle the same. So if I pay, he already gave the truck to me. He said that if I fail to, and also I paid the consideration amount also.
Now, what was the allegations in the
In the
complaint?
complaint, which is the complaint, it starts from page number 33. And the relevant page is page number 34.
What is your ground that
My
there is-
ground is that because the truck was misappropriated by a third party, he forcefully kept the truck with him. For that, even before filing of this complaint, before the filing of this, I have filed my case also. And because of the misappropriation by a third party who took my truck on hire, he is not returning the truck to me. Against that, I have filed a case also. Because of that, for many months, the truck is not with me. That is why, because due to the financial condition, the poor financial condition, I am unable to pay the EMIs. But whenever I get definitely my financial condition improves, I am ready to pay it. there is no, there is no dishonest misappropriation. Because it was not intentional, deliberate on my part.
No, but these pleas you can take before the trial court.
Already charge has been framed, Lordship. So cognizance has been taken. It is why I'm,
No, cognizance has been taken, summons. are
summons has been issued,
You have appeared.
and I'm yet to appear. But since because only saying that I am not paying the EMIs, and the reason.
On facts, whether 482, we can,
Because, yes, it is, my solution is that the ingredients of section 406 is not there in the complaint. With non-payment of EMI is not amounts to criminal breach of trust. Section 405, my humble submission is the Lordship, section 405.
we are issuing notice.
Whole thing is, start illegality, in a vehicle, if in hypothecation, no one can sell, no one can mortgage. Actually,
It is there, but as a
Heard Mr. B. Bora, learned counsel for the
further
petition,
proceeding, I'm praying for an interim pair.
that after service of notice on the,
Elsewhere may be called for, and then the further proceeding maybe is Lordship, still Lordship.
after service of notice. Because these plea you can take before the trial court also. You have not taken these pleas before trial court.
Well, I have to appear before the trial.
You have to appear. For that, you have other, unless it is a clear case where there is some violation, where the powers under 482 can be exercised clearly.
Also, because I have to go through the ordeal, Lordship, because since there is no ingredients of section, apparently there is no ingredients section 406, but I have to go through the ordeal of appearing before the trial court. It is this is and therefore the power.
No, whether there is ingredient of 406, because truck has been entrusted to you. There is a breach of entrustment.
But so in the, as per the agreement, Lordship, there is no.
Under certain circumstances, that breach has been committed. But
Lordship, yes, Lordship, my submission is also breach, Lordship, I am pleased to whether that was a intentional or deliberate or Lordship, may I rely on section.
for that, we have to go into facts.
As per the content of the complaint, it is clearly reflected that I have not committed any dishonest misappropriation. Let's say for 406, there has to be some dishonest misappropriation. Can I read section 405, Lordship?
No, you first read the allegation.
Yes, I will read the allegation, Lordship. The complaint number 2, this page number 32, that is the compressors and the content from 33. That a complainant is a businessman and he, for his business purpose, he has.
No, where is the specific allegation?
Allegation. Para 5, I am starting from. That to recover from the financial crisis, the complainant sold his vehicle to the accused in a total consideration of rupees so and so. Only on date so and so by an agreement for sale with a condition that the installments will be paid by the accused to the financier of the vehicle. That on good faith and complainant handed over the
No,
vehicle.
the allegation is neither you have paid the EMI, nor you have returned back the vehicle.
Because the vehicle is, because vehicle is misappropriated by third party. Against it, I have already filed a complaint. Police investigation is going on. And that complaint is before this complaint. So this complaint is filed on Lordship 14/9. I have filed my complaint on 8/11. This is on 14/9. My complaint was 11/9 prior to
Yes,
this
yes,
agreement.
these pleas you have to take before trial court. These facts are not known to the trial court. These facts which you are raising before this court are not known to the trial court. Trial court has proceeded only on the basis of the complaint.
Complaint of the informant.
If there is a defect in the complaint, we can interfere. But you are bringing certain facts which are not known to the trial court. Those you have to placed before the trial court.
I'm not, Lordship, my last.
Still, we are issuing,
Lordship, my last submission is that the trial, before a trial court, the agreement was there. And in the agreement, in clause number 11, it is clearly stated that, so I'm selling it to the, to my truck, to the petitioner, and for a consideration amount. And if the petitioner is unable to pay the EMIs, then finance company will take over the truck. So now he has already exhausted, he gave up all his right by himself, Lordship. So if you are paying it, if you will not pay, then finance company will take over. He's not saying that if you fail to pay the EMI, then you have to return back the truck. He's not saying in the agreement, Lordship. And the agreement was before the trial court.
okay. Heard Mr. B. Bora, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Riku Ahmed, praying for quashing the complaint case number 102/2023, an order as well as order dated 6/11/2023, passed by learned Chief Judicial Magistrate Kamrup Amin Rao, whereby cognizance has been taken under section 406 of the Indian Penal Code against the present petitioner. The gist of accusation in this case is that the respondent number
2,
respondent number 2 had filed a complaint case before the learned Chief Judicial Magistrate Kamrup, which was registered as complaint case number 102/2023, wherein it was alleged that the respondent number 2 is a businessman, and for the purpose of his business, he purchased a Tata truck bearing registration number AS01NC1127, and the said truck was purchased on hire purchase from Tata Motor Finance Limited. The respondent number 2 had entered into an agreement with the present petitioner with an arrangement that the present petitioner would that the said truck was handed over to the present petitioner on an arrangement that the present petitioner would repay back all the remaining installment to the finance company. However, it is alleged in the complaint that, taking simplicity of the complainant, the present petitioner, after taking the possession of the vehicle, failed to repay even a single installment to the finance company. You have not paid any installment,
Initial few payments I have made.
not single installment to the finance company. And therefore allegation of misappropriation as well as cheating has been made against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner had taken the truck from the respondent number 2 after executing an agreement for sale with the respondent number 2 on 12th of December 2022. And in the said agreement, there was a stipulation that that the that the respondent number, that the present petitioner would pay the EMI to the financer and on failure of payment of EMI to the financer financer may take over the possession of the said vehicle. No, this clause is in itself not complete. You read the clause 11, clause 11. Clause 11 may not help you.
After signing this agreement, a first party has no
We have to
liability.
issue notice only, no interim relief. Because of this clause, because after signing of the agreement would be terminated.
Since there is some liability fixed by the agreement on the seller also, that is why he is incorporating the agreement that he at liberty to terminate the agreement. But the finance company will take over the vehicle.
Finance company would take over the vehicle. And the first party has every right to settle the same with the financer. And also right to terminate the agreement with the present petitioner. First party, instead of first party, right, respondent number 2. Stop. Issue notice to the respondents. Since respondent number 2, since respondent number 1 is represented by the additional public prosecutor, no fresh notice need to be issued to the respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to the respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 3 weeks. The prayer for interim relief would be considered
Till then, not.
only after service of notice on the respondent number 2.
Wait, please, Your Lordship. This matter will have 439 application. Petitioner was arrested on 19/11/2022. It's a commercial quantity, but it is today's 401 days. Your Lordship. And in the FIR, which I will take Your Lordship to the FIR, which is page 11, in the FIR as well as in the charge sheet, the person, this particular petitioner has no whisper against anything against him, except the fact that he has not bought the railway ticket. The railway ticket was found in the other person, and that is the only ground he was arrested. Nothing was recovered from him. Even no implication was there in the FIR as well as the charge sheet. The Lordship will turn to the FIR at page 11.
Why charge sheet was filed against?
Charge sheet was filed on, Your Lordship, 13/5/2023.
No.
22.
Okay. What was the?
Sorry,
application?
23. Arrest was 19. Then, Your Lordship,
Okay. What
then
was the
Your Lordship, in
allegation?
the charge sheet also, not a single whisper, and even the recovery, Your Lordship, was also stated. Nothing was recovered from this person. Only thing was that when the person was traveling in the train, the ticket checker came, the GR police have come and they have checked the ticket. Then this person's ticket was not found, and the ticket was found from the other person.
23 and 22. More than 2 years.
No, actually 23. right. 11 on 23. Right. Then what has happened, Your Lordship? This ticket was found from the other person. When they were checked, then both the persons, Your Lordship, found packets of heroin, 500 grams.
of heroin in both the persons. So that was the whole.
From your position, nothing was.
Nothing in my position, and in fact, they have also not directly implicated me in the FIR, nor in the, your lordship, the charge sheet, your lordship. Now, the matter is pending, the
Charges are framed.
charges have not yet been framed till today, your lordship. Dates after, one person is absconding. Initially, charge date was fixed for filing charge sheet, but when the court came to know there is an absconder, then the
Charge
matter is
sheet has
going
been
on
laid under-
production on.
Charge sheet has been laid under 21C and 29. What are the ingredients of 29
Now, ingredients here, your
in
lordship.
this case?
In this case, your lordship, kindly see the FIR from that. I cannot say other with regard to the records, but from the FIR, your lordship, if your lordship see, the ingredients are also not there. Because if your lordship will see page 11 or the charts, page 11, your lordship, for a moment, if your lordship will see, with reference to the subject cited above, I have the honor to inform you that as detailed by officer so-and-so GRP, dated so-and-so on so-and-so, myself with so-and-so, so-and-so, along with GRP staff, started conducting a routine train checking at Guwahati railway station. During train checking in train number so-and-so, railway station in post number B1, we found a passenger who was traveling without ticket named Mohammad Mujibur Rahman. This is the petitioner herein. Aged so-and-so, so-and-so, so-and-so. On being suspicious and after seeing the facial reaction of the passenger, we asked about his journey ticket. On asking, he indicated to the two other passengers who were keeping his journey ticket. Again, when we came near the other two passengers and asked about the journey ticket, we checked and found that they were keeping the journey ticket in the name of the other person, which indicate that they were cheating the railway authority with false ticket, white number so-and-so, in the name of M. Rahman and Mujibur Rahman. Mujibur Rahman is the person here.
That
With-
means his ticket was with,
M. Rahman was with the other two persons.
okay.
So we checked also his body, and after checking his body, we found 2 packets from both of them. Suspected narcotic drugs to be heroin are in the lower abdomen, which were concealed with brown color sellotape. On asking, the apprehended person disclosed their name as Abud Ahmed, so-and-so, and to Ubedur Rahman, so-and-so. They are from Karimganj. They confessed that they were carrying the suspected narcotic drugs from Dimapur railway station to Katihar railway station to deliver the drug. The said recovered drugs were duly seized from the possession of the accused persons in presence of witness so-and-so, so-and-so, so-and-so. The said recovered drugs were weighted and found 1 kg, including the concealed plastic packet. Both Ubud Ahmed and Ubedur Rahman are keeping the drug into plastic of ½ kilo with them. After completion of formalities, we came to Guwahati. So it was registered under 21C 20. Now, your lordship, in the charge sheet, we thought that the same thing will come out with regard to the present petition. Again, the same thing at page 18, page 17 is the charge sheet. Page 18, the brief of the case, practically the same thing has been stated. Nothing with regard to the petitioner, only he has traveled without ticket. That is his in the forwarding, sorry. Then in the charge sheet, that is annexed at page 24. Page 24. Here your lordship will find at page, no, that's not. Page, the petitioner's name reflects that, yes, serial number 2 at page 26. Only his mobile phone and driving license were recovered from, nothing else. Then, with the other persons, the drugs have been recovered, it has been stated. Now your lordship will see that page in the page 40, page 40 again, in the charge sheet, it is as per the separate sheet, your lordship. The same story has been stated. The same story has been stated here also, and the same thing has been stated that drugs were recovered from these 2 persons, Abud Ahmed and Ubedur Rahman, and nothing specific against this petitioner. And then your lordship, under section 21 and C and 29, the name of the accused person is and closed, your lordship. And along with that, another person, Muhammad Hussein Ahmed, is also stated, and here, your lordship, he is still absconding, your lordship. And thereafter, your lordship, if any, your lordship, allegation is against that, then your lordship, it should have been incorporated in the charge sheet. And 29, your lordship has asked with regard to punishment for abatement of criminal conspiracy. There has to be something in the.
Now,
either in
what
the FIR.
materials are there to show that there was a conspiracy between?
That is not there in these two. From the charge sheet as well as the FIR or the forwarding, nothing has been shown. The only
And
thing
in
is that
this-
I was traveling without.
And in the statement, 161 statement,
161 and 164 statement, I think it's the copy. Third frame is not yet been framed, your lordship, so I don't have the copy of that. So I think the scan copy, if you're there is, I think my learned friend will be in a
Scan
better
copy of
position.
case there is there.
what?
Thing is, only case is not progressing due to non-appearance of
No,
one.
no, it is not a question of delay is not, you are on merit.
My lord.
That was the merit part. And second part with regard to, because till today, after about a year, about I
No,
think
delay-
401 days, even the.
Delay is
judges have
not a,
There's also delays there to an extent.
but they are on merit, that there is no material.
No, that is not correct. From the charge sheet itself appears, my lord. His ticket was with other person. They were, that means that they were traveling together.
No, but that does not mean that he is also.
And they have not managed the Caesar list also, my lord. Caesar list would have revealed from whose position actually it was seized.
Charge sheet, it has been given, the list from whose possession it is there. That is why I have shown your lordship
Caesar list.
in the charge sheet. Your lordship will see page.
Mr. Das, apparently it appears that there is nothing against the present petitioner except that his ticket was found with the co-accused. Now to implicate him under section 29, because 21C is not attracted. He was not found in possession of heroin, or if to attract 29 of the NDPS Act, something has to be shown that there was some conspiracy, that he was also knowing that they were carrying and he had some role. Some link has to be there. Mere finding of his railway ticket, is it enough? My query. What materials are there to show that 29 is attracted in this case?
No, in that case, my lord, what I submit, he has to take a plea that he is not in the conscious position. He doesn't know. He doesn't know that his co-passenger was co-accused was carrying, my lord, heroin. He doesn't know that if he takes that plea, my lord, burden lies on him.
No, not in this case. In this case, before he takes that plea, you have to show that how he is involved. You have
Then
only,
let it be taken after some time. I will examine the 161 statements.
you go through 161.
After some time,
There has to be some material.
at 2 p.m.
Okay. Let him go through the.
Let.
Item number 15.
None appears for the petitioner on call. Let this matter be listed on Tuesday. On Tuesdays, 9/1.
Item 16.
Your lordship may kindly forward this matter for time being, senior legacy on court number 12, your lordship. Thank you.
16 to time being.
Item 17.
17 is upon the session. Okay, Malak, maybe taken after some time. Yes, Lord is taken, Malak, after some. He's in another court, Malak.
After something.
May it please your lordship. 439 application lordship, FIR your lordship will find page 11 and relevant portion at page 13. Here in from page 13 onwards, your lordship will find two things I am pointing out from the FIR lordship. First of all, the search and seizure was made at night and he was not present in his house, lordship. And in the FIR, the main allegation is against his father. So father was apprehended and the contraband were recovered from the house. And thereafter, your lordship will find page 16 is the forwarding report. And page 15 is the forwarding report of his father. He was arrested on 19/7/2022. And the present petitioner was arrested on page 16, your lordship will find 2nd February 2023. So grounds of arrest, may I read that?
Yes.
Ground of arrest, the arrested person is the FIR named accused. The accused person is arrested in order to prevent from committing further offense. During investigation, sufficient evidence found against the arrested accused person. The accused person may manipulate witnesses and may tamper evidence. The Yaba tablets, image dated so and so, image sample of Yaba was found at the accused Vivo phone, which is noted in the seizure memo. The accused person also admitted himself that he act as an intermediaries for earning commission by transporting narcotic drugs between the seller who is from other state, Mizoram, and the consumers and the customers from Assam. So this is the ground. And now, lordship, I'm just again taking your lordship to the FIR, page 14.
Yes.
In between 1, 2, 3, 4, fourth line from bottom, your lordship will find the house owner Asabuddin. Lordship.
Yes.
The house owner Asabuddin could not give satisfactory explanation about source of seized drugs, and he revealed that his son Farooq Ahmed have recently started peddling of drugs and might have kept those tablets concealed inside a school bag at his cow shed. So that was recovered from a cow shed, lordship. And currently he is at Mizoram for some work. So the petitioner was at the relevant time was at Mizoram. And the father of the petitioner Asabuddin was granted bail, lordship. That order your lordship will find at page 17.
No.
Sorry, lordship, it is not 17, lordship. It is mentioned in page 17. Page 18, your lordship will find page 18 in the rejection order. It is mentioned. Page 18, second line, lordship. It is further submitted that, lordship.
Yes.
It is further submitted that this court by order dated 30/1/2023 granted bail to co-accused Asabuddin on finding out that the IO has submitted part charge sheet against him. Thereafter, white petition number censor bail petition of the Farooq Ahmed was rejected. So he was granted bail because part charge sheet was submitted. And the initial charge sheet your lordship will find page 21.
Part charge sheet against the father.
Father. And subsequently supplementary charge sheet was submitted. No new material is submitted. Only that the material which was submitted at the initial point of that is there. Page 21 is the first charge sheet. Page 37 is the second charge sheet. Pardon. But no new material.
Now, what is your submission?
My submission is that nothing was recovered from his possession, Lordship, and father, from the FIR also, your Lordship will find that information was regarding his father. So his father was arrested, his father got bail, Lordship, and as his Lordship, his father was arrested, because of that relationship, he was Lordship subsequently apprehended.
Your father himself implicated.
No, his statement of co-accused that Lordship, that Tufan Singh will come, Lordship.
Okay. So except
Except that statement, nothing is there. And there's a first limb of submission, which I have already pointed out, that entire Lordship search and seizure was made at night, Lordship. That your Lordship will find page 13, second line itself, that 2 a.m. at night. And they returned to PO at Lordship may I say page 13, second line of the FIR. Page 13, second line. 2 a.m. they started, and page 14, the paragraph which I have already shown to your Lordship, that next paragraph, page 14. After completion of all formalities, the police party departed from PO at
there
5
was
a.m.
any violation.
Yes, that 42 will come.
It
That
was not,
they can search at night, but they have to record their reasons.
it is not there.
It is not, probably it is not there.
42 clause 2,
Lord
proviso 2.
Proviso. And this raid was done on the basis of prior information. Page 13, first line, your Lordship will find. Whether proviso and subclause 2 they complied with, that is it. And a statement of coercion.
You have that judgment where 42 is not.
Yes, Lordship. So is the one person, right?
Yes, Mr. Das, you see whether their plea is that though the contraband was found in the house of the co-accused, the present accused was not present. And only on the basis of the statement of father, he was arrested. So statement of father is not admissible as per Tufan Singh's case. That is your submission.
what-
And there is a violation of section 42. I don't know whether they are alleging that there is a violation. You have to see whether reasons for conducting search during night, whether it was mentioned by the IO or not.
Otherwise, my lord, he is in the conscious position, my lord. It is in his conscious position, lordship. If we look into the 106 of the Evidence Act also, if there is any special knowledge, my lord, if the burden lies on that person, lordship. If we look into the evidence, 106, my lord, it is clearly stated in clear burden of proving facts, especially within knowledge. When any fact is especially
No.
within knowledge of any person, lordship.
No, 106 will not come here.
Lordship.
Here the contraband was found from his house
Lordship.
when he was not there. He was
Lordship.
in Mizoram.
Lordship.
House belongs to his father and also belongs to him.
He also resides there.
He also resides.
But in the FIR also it is that owner is.
He himself also stated that, my lord, though it is there in
their
161
plea
statement,
is-
my lord, he
their-
is an intermediary, lordship.
No, their plea is that
Lordship.
the contraband which was seized
Lordship.
was seized from the house when father was present.
Lordship.
Father said that this might be kept by his son.
Lordship.
Son was in Mizoram. They are saying that this statement of father is not admissible
Lordship.
because this is a statement of a co-accused. Is it your submission?
And that too, he said, Lordship, might have. He has not specifically said that I have killed. Might have.
Might
Have. He has not
Might
said that I have killed.
Okay.
He's not sure that I have kept. He said I might have, and the contraband was
On
recovered
this, you
from
have to answer
Southside.
first. Second plea is that the search was conducted after 2 AM, it completed before 5:30 AM.
Lordship.
So for conducting search in night, special reasons for conducting search has to be mentioned under section 42.
42, Lordship.
If that is not mentioned, they have relied upon a judgment of an apex court, of the apex court, that they will get benefit. On that you have to answer.
Lordship.
When will you answer?
I have given him a
Tomorrow,
copy.
Lordship. On to Saturday, Friday.
At two,
My Lordship, Monday.
at two, Lordship.
So I have a Lordship. I have to go through my Lord. I also have to search the citations, Lordship.
But this is fixed for bail hearing.
Very good.
So it is expected that I will allow you time.
Lordship.
Let them answer. Whether there is a compliance of 42 is there or not,
Lordship.
that you have to help this court.
Lordship.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar. Though learned counsel for the petitioner has made his submission. Learned-
KK Das, Lordship.
Sorry, K. Das. Learned additional public prosecutor has prayed for some time for replying to the submissions made by learned counsel for the petitioner. The prayer is allowed. Let this case be listed again on 8th of January.
On the last occasion, Lordship, there was a discussion whether how the provisions under section 37 can be dealt with. Lordship, I am pressing one precedent, one judgment, Lordship, where section, how to overcome the provisions of section 37 has been discussed here, Lordship.
No, you have to refresh what was the fact.
Lordship, the case pertains to confiscation of
How many days?
till today, Lordship, 520 days, Lordship. I was arrested on
520 days means how many in years?
1 year. I was arrested on August 1/8/2022. 13 months.
5 months, Lordship. 1 year, 5 months.
1 year, 5 months. Lordship.
So do you have any precedent where
Lordship,
in
I am
1 year,
like-
1 year, 5 months bail has been granted?
Lordship.
I have not come across any precedent.
Yes, Lordship, the case which I am referring to, Lordship, there, they are discussing about this, the delay in trial, and here in my case also,
No,
Lordship, not a single
I
witness,
agree that there is a delay in trial,
Lordship.
but how much delay will give you benefit of that prolonged incarceration?
Lordship, that is a gray area. I have not come across.
Yes. There I required your help because I have come across apex courts judgments in few cases where 1 year, 6 months is considered as prolonged incarceration. So you are still 1 month less than that.
Lordship,
So your case falls below that standard.
Lordship.
So unless you show that
In that case, Lordship, I will pray for some more time so that I can do some more research and come back again, Lordship.
yes, that
Even Lordship, is free status report may be called for, Lordship, because it was the status report which we have received, that is of November, Lordship. So what is the present status report?
heard
That
Mr. P.P. Medhi, learned counsel. What was the, how much contraband was seized?
Lordship, from three accused persons, 40 kgs of ganja, Lordship.
40 kg ganja. And what is the status of the trial?
Lordship, till now, not a single witness has been examined.
Okay.
There are 7 witnesses in this case. Lordship.
5.
Okay.
Five.
Heard Mr. P.P. Medhi, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor. Learned counsel for the petitioner has prayed for some more time to to place some authorities in favor of his case in support of his case. On the other hand, learned additional public prosecutor has submitted that the scanned copy of the case record is up to date only up to November 2023. Hence, an up-to-date status report may be called for from the trial court. Stop. The prayer of the petitioner is allowed. In the meanwhile, let an updated status of the NDPS case number 235/23 be called for from the trial court. Let this case be fixed again in the second week of February.
I'm obliged, your lordship.
Item 19.
19. Over the road. 19. Oh, what will it? May I please your lordship? My lord, on the last occasion, my lord, I took time from the honorable court to submit one judgment in my favor, my lord. My lord, here in this case, my lord, I was arrested on 28/10/2022, my lord.
28/10/2021.
My lord, till today, my lord, 2 years, 2 months and 8 days I am behind the bar. Search sheet was filed on, my lord, 1/8/2022.
2 years.
2 months and 8 days, my lord. From 28/10/2021.
Okay. What was seized?
Heroin, my lord.
How much?
21 grams.
21 grams.
281 grams.
How much?
281.
281 grams.
My lord, along with me, my lord, another person was searched, my lord, who was declared as absconder, and due to his non-appearance, my lord, still charge was not framed, my lord. Even that search sheet was filed on 2022, my lord.
When it was filed charge sheet?
My lord, on search sheet dated 8/2/2022, but it come to honorable learned trial court, my lord, on 1/8/2022. Lord, search sheet on page number, my lord, 24. It is written that search sheet dated 8/2/2022, but the same was put up before the learned trial court, my lord, on 1/8/2022. My lord, after another 6 months. My lord, actually, I was entitled for default bail also, but due to lack of knowledge of that accused person, my lord, bail petition was not moved. So, my lord, last more than 2 years, my lord, he is behind the bar. But kindly, I may be allowed to go on bail, my lord. I am today, my lord. I am
brought the judgment.
Yes, my lord. Muhammad Muslim Hussain, Farzad State of NCT. Kindly.
Yes, Mr. Das.
My lord, only because of this non-appearance of Sahabuddin, who is absconding, my lord, against him, non-malleable warrant of arrest has been issued. My lord, the contraband was seized from him. So, my lord, with all respect, on merit, he is not entitled to bail. Number one. Number two, my lord, if my lord, he is not found, subsequently he will be declared my lord, absconder, and my lord, learned court will proceed against him. My lord. Your lordship may kindly direct that to expedite, my lord, the trial, my lord. Because contraband was seized from him. No. He was carrying it.
This is also, my lord, doubtful whether contraband was seized from me or not. In the record, my lord, that was seized from me, but in the FIR, my lord, it is clearly seen that in page number 12, my lord, it is seen that in page number 12, my lord, I may read out the FIR, my lord. One of the suspect, namely Mojibur Rahman, my lord, in FIR, my lord, in spite of the contraband seized from me, I was said as suspect, my lord. The accused person said that the bag belongs to that accused person, who is my villager, my lord. He fled away immediately, and therefore this investigating agency arrested me, my lord. This is his person, my lord. Now,
You know, that the word suspect is used because till seizure, my lord, it is not sure the informant that whether it is contraband or not.
my lord. considering the undue delay in trial, my lord, and my length of detention for more than 2 years, my lord, I may be allowed to go on bail, my lord. I am a local person, my lord. I will appear, my lord, regularly. I am local person, my lord.
One is already absconding and he absconds subsequently.
I will not
And
abscond, my lord.
which
I am
quantity?
local person, my
281
lord. I will
commercial
appear, my
quantity.
lord. I will appear, my lord.
Heard Mr.
R. Sharma, my lord.
R. Sharma, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mojibur Rahman, who has been detained behind the bars since 28/10/2021 within bracket for last 2 years, 2 months and
8 days.
8 days in connection with NDPS case number 168/2022 pending before the court of learned. Which court it is pending?
My lord, Honorable Special Court, Kamrup Metro, my lord.
Pending before the court of Additional Sessions
Session.
Judge number 3 within bracket FTC Kamrup Metro. The gist of accusation in this case is that on (27/10/2023), one Shri Rohit Das had lodged an FIR before the officer in charge of Special Task Force Police Station Assam, inter alia, alleging that on receipt of an information through reliable sources that some illicit drugs were being carried by some person at Lanka in Hojai district. The informant, who is a member of Special Task Force, proceeded to Lanka to launch a search operation, and they conducted a search operation in front of Ashik Nursery near National Highway number 54 under Lanka Police Station, and apprehended the present petitioner therefrom, and recovered 16 packets from his possession, 16 packets containing 280 grams of suspected heroin from his possession. On receipt of the said FIR, STFPS case number 5/2021 was registered and investigation was initiated. Ultimately, after completion of the investigation, charge sheet was laid against the present petitioner and one Sahabuddin under section 21C of the NDPS Act, 1985. So, learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since 28/10/2021. That is for last 2 years, 2 months and 8 days. And though the charge sheet was laid before the trial court on 8/2/2022, before the trial court on 1/8/2022. However, till today, not even the charges are framed in the said case. It is also submitted by the present learned counsel for the petitioner that the co-accused, namely Shahabuddin, is absconding and therefore trial could not be proceeded. Learned counsel for the petitioner has submitted that the petitioner is, you have cited Muslim Ali.
My lord,
The petitioner is entitled to get bail on the, mainly on the ground of prolonged incarceration, as per the observation of the apex court in Muhammad Muslim Ali alias Hussain versus state within bracket NCT of Delhi, reported in 2023 SCC online SC 352. On the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioner on the ground that the contraband seized from the possession of the present petitioner is of commercial quantity, and therefore embargo of section 37 comes into play. It is also submitted by learned additional public prosecutor that the petitioner, that the trial of the present petitioner could not proceed only because of the fact that the co-accused Shahabuddin, who is absconding, is yet to be apprehended. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the scanned copy of the case record of NDPS case number 168/2022. Stop. Though this case involves commercial quantity of contraband, however, considering the fact that the petitioner has been detained behind the bars since last 2 years, 2 months, 8 days, the question before this court is that as to whether prolonged incarceration of the petitioner would override the embargo of section 37 of the NDPS Act 1985. Stop. And if this court comes to a finding that delay is long enough so that it would outweigh the embargo of section 37 of the NDPS Act 1985, he may have to be released on bail in spite of the embargo of section 37 of the NDPS Act. Stop. It appears that the delay in trial is mainly because of the fact that the co-accused is yet to be apprehended. However, the present petitioner is not at fault for the delay caused in the trial, as he has been detained behind the bar all along since the date of his arrest. Stop. The petitioner has a right to get speedy trial under Article 21 of the Constitution of India. Then quote paragraph number 14 from 14 from bail application number 3852/2023. The 2-year asylum. Huh? Para number 14. Quotation of Mahibu. It will continue as a paragraph. Quote from here. Quote para 14. Then para 15. Para 16. Para 17. The next para. In the instant case also, the petitioner has been detained behind the bars since 28/10/2021. Within bracket, since for last 2 years, 2 months and 8 days. And the charges are yet to be framed. There are how many listed witnesses?
I have to check.
There are dash numbers of listed.
7, my lord.
7 numbers of listed witnesses in the charge sheet. And there is the likelihood that culmination of trial would take some time. And same time. Stop. Under the facts and circumstances of this case, this court is of considered opinion that long incarceration of present petitioner for last 2 years, 2 months and 2 years, 2 months and 8 days, comma, in the facts and circumstances of this case has outweighed the embargo of section 37 of the NDPS Act, 1985. Hence, this court is of the considered opinion that the petitioner is entitled to get bail in this case. In view of above, the petitioner, namely Mujibur Rahman, is hereby allowed to go on bail of rupees 50,000 with 2 sureties of like amount. Where do you reside?
My lord, Hojai,
Permanent residence of
Hojai, my lord.
50,000 with 2 sureties of like amount. Subject to satisfaction of the learned trial court. Subject to the satisfaction of the trial court with following conditions. The petitioner shall cooperate in the trial of NDPS case number 168/2022, which is pending before the Court of Learned Additional Session Judge, FTC number 3, Kamrup Metro. The petitioner shall regularly appear before the trial court as and when so required by the trial court. The petitioner shall not leave the jurisdiction of the trial court without prior permission of the trial court. And when such leave is granted by the trial court, the petitioner shall submit his leave address to the contact details during such leave before the trial court. The petitioner shall also provide his contact details, including photocopies of Aadhaar cards / driving license / PAN card, mobile numbers and other contact details to the learned trial court. The petitioner shall not directly or indirectly make any inducement, threat or promise to any persons who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts before the trial court in the trial pending against the present petitioner. With above observation, this bail application is hereby disposed of.
Deeply obliged.
In item 22, my lord, charge sheet has been submitted.
May I pray lordship, the scan copy may be called for lordship case diary, because nothing has been recovered this from petitioner lordship. Later on, after
No,
2 months,
after charge sheet, you have to pray before the trial court.
is a commercial quantity.
But you have to go there
Lordship, pass of the
because
order.
this application was filed during the pendency of the investigation.
Lordship. So sometimes lordship, some court,
But during trial, the best court is the trial court. Let the trial court first consider.
commercial quantity lordship. Let it. Let a scan copy may be called for lordship.
if it is charge sheeted and if it is commercial quantity, then this petition is liable to be rejected now.
Then reject it, Lordship.
Okay. How, yes, Munir, learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor. Learned counsel for the learned additional public prosecutor has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has been laid. Under what provision charge sheet has been laid?
My lord, that is not, we have received message through WhatsApp, my lord, only.
You know that it is laid under 21C.
21.
We have see on it, Lordship. We have, quantity was commercial
Charge
quantity.
sheet has been laid.
Charge sheet number, my lord, 3/2023.
Bearing charge sheet number 3/2023.
2023. Dated 22/12/23.
Learned counsel for the petitioner has submitted that charge sheet has been laid under section 21C of the NDPS Act. As the charge sheet has been laid under section 21C of the NDPS Act for possessing commercial quantity of the contraband, embargo of section 37 of the NDPS Act comes into play, and hence and
25.
the petitioner has failed to show that show anything which would help him to overcome the embargo of section 37 at this stage.
Lordship.
Therefore, the prayer for bail is rejected at this stage.
Lordship, that. May approach to trial court, Lordship, one line may be.
The petitioner may, when I am rejecting,
Lordship.
then trial court is
Lordship.
unlikely to,
Lordship. Then next round we can come, Lordship, going there, Lordship.
after going there,
Lordship, one line may be added, Lordship, that may approach if.
the petitioner may approach the trial court for seeking regular bail before the learned trial court, if so advised.
Lordship, that will do. Lordship. Much obliged, Lordship. Much obliged, much.
The report received evaluation service also completed evaluation. Someone appear evaluation on behalf of informant evaluation. Yes, this is
Item number 25.
25 years. Today submitted someone Wakalat Kama evaluation.
Who is appearing for?
Wakalat Kama submitted evaluation.
Name has not been reflected, Lordship, in the cause list, Lordship.
Today submitted evaluation. Cause list published earlier evaluation.
Name has not been
Let
reflected.
the name be reflected in
Lordship.
the cause list.
In online available evaluation. Now.
No, it has not been shown in the cause
Cause
list.
list, Lordship. That is
So the council may not be knowing,
away.
aware of the listing.
Today submitted evaluation.
We are fixing it after 2-3 days so that heard Mr. A.A.R. Karim, learned counsel for the petitioner, also heard Mr. P.S. Lawcon, learned additional public prosecutor. The scanned copy of the LCR has been received. It is also pointed out by learned counsel for the petitioner that counsel for respondent number 2 has submitted Wakalatnama today. However, it appears that the names of the counsel for respondent number 2 has not been reflected in the cause list. Hence, let this case be listed again on 9.
8 evaluation Monday.
9.
9, Lordship.
9.
On 9th of January, after reflecting the names of the counsel for respondent number 2 in the cause list.
Made to the Lordship. Mr. Aspiro is running fever. He could not come yesterday, today also. He's ill. So if your Lordship permit me not, I will send because case diary has already come.
You are not engaged, you are also engaged,
I am the petitioner, my lord.
or you are the petitioner.
Yes.
Now, what do you want?
Petitioner person. I want to move because since my lord Kesdari has come, your lordship can take up the matter.
আপুনি এটা petition হ'ব নালাগিছিল।
Okay.
অভিজিৎ শইকীয়া তেখেতে আপুনি accused নহয়।
Thank you.
Actually,
Thank you, sir.
she is the mother of the accused, lordship.
But she is also the petitioner,
Yes, sir.
so she can move in person.
Kesdari, your lordship.
Kesdari will
He will
come
place
up
the
with it.
Kesdari, then I'll.
You have appeared,
I'm appearing, my lord, when he will be okay, my lord, because yesterday. when
you are
I
still in
released-
hospital.
No, my son is released, my lord.
Whether the,
He has to be operated, my lord, very soon. Yesterday we visited.
no, whether the,
hospital.
whether the,
Some hernia and some problem has developed. And SP Roy not in hospital, but he is unable to almost talk. Very high fever is running, my lord. I talked to him.
no, what is your prayer now?
I want to move, my lord, because he may be, when he will be cured, yes, I want to move. Because my prayer is, my lord, to, after going to the city, make the absolute, because since they don't have any jurisdiction.
No,
I
whether
have
the,
filed-
whether
and
you
we
have
are
a,
not, cattle, my lord, cattle, only the live cattle and my lord, the meat that, my lord, slaughter of cattle, all these things are dealt with.
whether
And
the
in my
petitioner
case,
has
it's a
appeared
process
before
meat.
the IO.
They have, he
And-
has appeared, my lord.
And
His
his
statement
statement,
is also there.
recorded.
Abhijit Shaikia.
statement is recorded.
They recorded, my lord. My submission is that, my lord. In the seizure, the quantity is 2630 kg of buffalo, lordship, not buffalo, it's cow, because FSL beef, lordship. In the FSL report, it is clearly stated it is
No,
beef.
he-
However, documents are there. We have shown that it is buffalo, lordship. Moreover,
The forensic report has come as buffalo.
beef,
We don't know.
cow antigen,
But later
No,
when.
cow
Mr.
antigen.
Das,
Lordship,
if the petitioner has appeared,
lordship,
his statement is recorded,
lordship.
whether you require his custodial detention.
Lordship, because I want to state here only, as per section 8 of this act, my lord, there is no person shall directly or indirectly sell or offer or expose for sale or buy beef or beef products in any form except at places permitted to do so by competent authority.
Okay,
Competent authority is not there. Moreover, provided that no such permission shall be granted in such area or areas which are predominantly inhabited by Hindus. There is temple is there, lordship. Within 2 kilometers, this sale is going on. And in order to know who are the other persons, because this is a racket. So in order to know who are the persons whom this further sale, my lord, subsequent sale has been made, it needs to be unearthed, lordship.
so for
In
that,
my opinion, lordship.
for that, what you require? Whether his custody, we will direct him to appear before IO. On more,
May I submit, my lord? After its completion.
Lordship.
Because
no,
it's
you
a
have,
packaged food.
you have
It's a
appeared.
packaged food.
No, we are not going into merit.
We cannot.
We
are not going into
yes,
merit.
my lord. We cannot
Now,
think of doing all such things, my lord.
Assuming that allegations are true,
Lordship,
assuming that allegations are true,
lordship,
the accused has appeared,
lordship.
you have recorded his statement.
Record statements. are
Now my
recorded.
query is whether his custodial detention is necessary. If it is not necessary,
Yeah.
we will direct him to cooperate with the investigating officer. He will come to investigating officer as and when you require.
Yes. With stringent conditions, then, lordship.
Heard, Miss. This is item number. Heard Miss N. Sakya, the petitioner in person. Also heard Mr. K. Das, learned counsel for the learned additional public prosecutor. The petitioner in person has submitted that the accused
Otherwise, in fact,
Abhijit Sakya, who is the son of the present petitioner,
remove the person and
was granted
এখন বনাই
interim anticipatory bail.
Okay, আপুনি কওক, আপোনাক দিব না, আপুনি দিব.
তোমালোক জানিব দিছে।
It is my duty,
Jurisdiction
no?
নাই।
It is duty my to save. It is my duty.
Sorry.
You have any,
No, my lord, I have only asked him to read the section 11 on.
No, my lordship, it's stating, my lord, that why I am
Oh, no.
arguing on this sec. I said, my lord, this is otherwise I will not protect this.
Sorry, my lord, sorry, if he is taken under.
You will, my lord.
Sorry.
yes, interim anticipatory bail on 12 by this court on 12/12/2023. And it is submitted by by the petitioner that the accused Abhijit Soikia has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Gosaigaon PS case number 381/2023 and has submitted that there are sufficient incriminating material against the present accused person. However, he has also submitted that the accused Abhijit Soikia has appeared before the investigating officer and his statement under section 161 has been recorded. Stop. Considering the fact that the accused Abhijit Soikia has cooperated with in the investigation and has complied with the directions of this court is of considered opinion that his custodial detention may not be necessary if he continues to cooperate in the investigation. His custodial detention may not be necessary for fair completion of the investigation of Gosaigaon PS case number 381/2023 if he continues to cooperate in the investigation. In view of above observation, the interim anticipatory bail granted to the accused Abhijit Soikia by order dated 12/12/23 by this court is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. The petitioner shall also appear before the investigating officer as and when so required by the investigating officer for the sake of fair investigation of this case. With above observation, the anticipatory bail application is hereby dispersed.
Bail application, this is my lord bail application, not anticipated.
Oh.
Bail application, yes.
This is bail, this will be above observation. This bail application is hereby dispersed. Anticipated to category. Let a copy of this order be furnished to the learned SDGM M. Gosaigaon / Chief Judicial Magistrate Kokrajhar also.
I'm like.
May it please, your lordship. Lordship. Beyond the bar last 50 days, my lord. Allegation, my lord, 379, my lord. My lord, kindly see page 8 FIR, my lord. This one is shown erase, but earlier case is my PS case number 127.
Case diary is there.
My case diary is not there. In the petition, it is written here charge sheet, but I don't have the number, lordship. At 2, lordship, I will.
Charge sheet has been filed.
It is written on the petition, lordship, but no number is there. So I maybe take instruction, lordship. At 2.
Okay. If it is charge sheeted, you have to go to trial court.
Lordship.
Let him find out.
At 2, my
At
lord.
2.
My please, Lordship. Lordship 439 application, Lordship. Registered offences are 332, 353, 427, 34 IPC, Lordship. And I have been behind the bars for last 52 days from the date of production, Lordship. That is 14/11/2023, Lordship. Can we see, Lordship, FIR page 8, Lordship?
Yes. Yes.
Lordship, only allegation is that Lordship, while I was playing friendly cards with my friends, Lordship, with the other accused person, Lordship, suddenly police came, Lordship, and seeing police, I escaped from the place, Lordship. I was running, and the police was running after me, Lordship. Police is the informant, Lordship, and he was trying to apprehend me, Lordship. And Lordship, after being apprehended, Lordship, the other accused persons were requested the police, Lordship, not to arrest because there nothing happened between the friends, Lordship. And Lordship, police misused the power and lost the affair after fabricating the whole incidents, Lordship. And the allegation, Lordship, assaulting and damaging mobile shop are completely false allegation, Lordship. Only allegation there's, Lordship, I was fleeing away, seeing the police, Lordship.
But there are allegation of assault or tearing the uniform.
Lordship, police is the informant, Lordship. Just to make the case strong, Lordship, these allegations were leveled against me, Lordship.
Investigation, what is the progress?
Lordship, 2 persons have been arrested and they have also stated that these persons were in alcoholic conditions, Lordship. This person, the petitioner, and they also stated that they pushed the persons and during their scuffle, Lordship, the shirt has been torn, Lordship. And for Caesar is also there. Mobile has been torn, my lord, broken down.
There are incriminating.
There are incriminating materials are there, Lordship.
But now whether further custodial detention is necessary. They are behind the bar since last 52 days.
Lordship.
Lordship, I leave it to Lordship. Otherwise, material is there.
Okay. Heard Mr.
A.K. Ahmed, Lordship.
A.K. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional for the prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Amrit Kumar Singh, who has been detained behind the bars since 14/11/2023, within bracket for last 42 days.
52 days, Lordship.
Sorry, for last 52 days in connection with Vasishtha PS case number 706/2023 under section 353, 332, 427, 34 of the Indian Penal Code. The gist of accusation in this case is that on 14/11/2023, one Saddam Ali lodged an FIR before the officer in charge of Vasishtha Police Station, inter alia, alleging that the informant, who is a home guard, on 13/11/2022 was on duty
32.
and they got information that 2 persons were quarreling, and thereafter the informant along with the core staff rushed to the place and found 2 persons were assaulting each other. And were assaulting. He came to know that the present petitioner Amrit Kumar was assaulting one Mukesh Singh, who had sustained injuries. And when the informant apprehended the petitioner, he escaped from the custody of the informant. And when he was chased and was chased by the informant, the accused persons named in the FIR assaulted the informant and tore the uniform of the informant. Stop. Learned counsel for the petitioner has submitted that the petitioner and his friends were playing cards and they ran away after seeing the police, and the allegations made in the FIR are not true. It is also submitted by learned counsel for the petitioner that the petitioner has been detained behind the bar since for last 52 days, and considering the period of detention also, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioner on the ground that there are incriminating materials against the present petitioner in the case diary. However, he has also submitted that in the meanwhile, investigating officer has recorded the statement of relevant witnesses. Stop. I have considered the submission made by learned counsel for both the sides and have perused the materials on record, including the case diary of Vashishtha PS case number 706/2023. Stop. Though there are incriminating materials against the present petitioner in the case diary, however, considering the progress made in the investigation, as well as considering the period of detention already undergone by the present petitioner, the further custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of Vashishtha PS case number 706/2023. Stop. In view of above, the above named petitioner is hereby directed to be enlarged on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition 1 and 2. With above observation, this bail application is hereby disposed of.
Much obliged.
My pleasure, Lordship. Also, in this case, Lordship, CD was called for.
Charge
So
sheet,
far-
charge sheet submitted.
Charge sheet submitted.
Heard Mr. G. Uddin,
AK Azad, Lordship.
A.K. Azad, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who submits that though the case diary was called for in this case, however, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
464. And dated 31/12/23.
in view of laying of the charge sheet. This bail application is disposed of with an observation that the petitioner may approach.
On the length of detention, Lordship, I would like to submit few lines, Lordship, though charge sheet has been submitted.
Go before trial court.
Lordship, offenses, Lordship, 379 years on today, Lordship, 36 days, Lordship, behind.
No, you have to move before. Petitioner may approach the trial court and may pray for regular bail before the trial court if so advised.
Lordship. God bless.
Item 58 from supplementary. 58.
This matter, day before yesterday, I've argued. And there was only one point that your lordship has already mentioned with regard to whether section 37 will be attracted when there is a violation, mandatory violation of article 42. Oh, sorry, section 42 of the MBBS Act. Here, just before going into the matter, I'll just refresh your lordship.
Yes.
The charge sheet was filed under section 21C29, which person is behind the bar for 340 days. There was a recovery of 282 grams of heroin.
How
which is
much?
when your lordship, the person was arrested from the road, the highway near Excel Hospital, and then I'm giving because that day I have already argued.
I
He
forget.
was taken to the, yes. Oh, you have law.
Because I deal with so many cases.
Then I'll just point out.
You
So
just
what is hap-
refresh it.
So basically, the point that day your lordship has recorded in the order itself, whether 37, how it will be overcome. when there is a mandatory violation of section 42 of the NDP.
So the search was made at night.
That night after 9 p.m. 9
After
p.m.
9
this
PM.
person was arrested. He was taken to a rented house. Then I have shown the evidences of the three PWs. Their evidence are not very conclusive, Your Lordship, in the fact that they did not know what has been seized. They have not seen what items are seized, how many boxes are seized, which room it has been done, from where it has been seized. I have already annexed these documents, the PWs, in the additional affidavit that they have read. So I am not reading again, but just pointing it out that in the additional affidavit, if Your Lordship will see, 3 PWs I have annexed at page internal 9 and serial 39. PW1, Your Lordship will see. At page 40, the PW1 said, these are all, Your Lordship, independent witnesses who says that I do not know exactly what has been seized. Huh? No, he is পড়াশোনা আছে। পড়াশোনা আছে।
Okay.
So what has happened on that, Your Lordship, then all the three could not specifically pinpoint from whom it has been seized.
Mr. PP is AK Parashar.
Yes. That day he was
I have
there,
not-
Your Lordship. He said, I'll just go.
I have not looked to it.
You have to show what was the violation.
The violation was, Your
Your
Lord,
first submission is that the
My-
witnesses have not
clearly
it-
implicated me.
implicated, but that we cannot see now.
Yes,
We will see whether there was a violation of 42
yes, violation of
and
40.
whether it helps you in getting bail
Yes.
in
that-
spite of 37.
37. That initially that day I have shown judgments with regard to 42, which is a mandatory provision.
Yes.
This
Which-
provision,
Which was the
3
judgment?
judgments I have
Shivraj.
given that day. I'll just refresh Your Lordships. It is there, I think, Your Lordship. The first judgment was
Shivraj.
After to করে দিও নিজে তো।
এক মিনিট, বস্তুখিনি কৈ দিওঁ, তাৰপিছতে refresh টো কৰি থওঁ।
Okay.
Just a minute, Your Lordships. The 3 judgments, Your Lordship. First is State of Rajasthan versus Jagraj Singh, Hansa. Then, Your Lordship, I have given one another judgment, that is Bhutta Singh, and others was the State of Haryana. This is a recent judgment, 2021 SCC online, SC 324. Then the final one was a Bombay High Court judgment, wherein Your Lordship, 2022. This is Sivraj Gorak Satpute versus the State of Maharashtra. These 3 judgments that I have given, Your Lordship. Here, Your Lordship, in the judgment of Bombay High Court, basically, Your Lordship, what has happened? The court has given the bail, but did not mention anything with regard to
It has
37.
not discussed 37,
Yes.
but
And-
given the benefit of
Yes.
it.
And the
My
other,
query was, is there any specific authority which says that if 42 is violated, 37, in spite of 37, you will get bail?
yes, that day, I think I could not produce the judgment. I said there were judgments. Yes, I've got the judgments today. I can give it to Your Lordship. These are, there are, basically, I am giving 3 judgments, but mainly the Supreme Court judgment, which is important now.
Now, what is the violation?
Violation was section 42, 2 things. Your Lordship. First and foremost, the person was arrested. Earlier, he was already arrested and then taken to the house where the charge was done. He was arrested at 9 p.m. Church was done after that. So it will be in the between sunrise and sunset. Sorry, it will be after sunset, before sunrise. It was December, Your Lordship, the month of December. So after 9 p.m., it's obviously very night. So that was one ground. Secondly, there was no noting, whereby it has been stated by the PIO that the grounds for it should be written, there should be a written ground why the church was done at that point of time. That has not been given. These are the 2 violations. Against that, Your Lordship, I have come.
And PP was asked to see whether
People
there
was
was,
asked to see whether The
There
put-
is
Yes, whether the
endorsement is.
endorsement is there. According to me, your lordship, there's no written endorsement. But PP was supposed to see that whether there is some written, he has seen, but he said that I could not find, but even then he wanted to see again.
Okay,
That was the basis.
then we will continue at 2.
Yeah. I'll show the judgment, that's it. তোমালোকে কত চাই?
দুটাত মাতিব।
অকল এটা
First month.
I have asked him to go through now, your lordship, so that at 2 he can assist your lordship.
Yes, even if Mr. Locker is
Lordship,
not there, is
Since
there
he-
any endorsement?
Lordship.
Only
What is your name?
B Goswami,
Third Miss B Goswami, learned counsel for the respondent number,
respondent 2.
respondent number 2, who prays for some more time for filing the written objection in this case. Learned counsel for the appellant does not opposes the said prayer. The prayer is allowed. Let this case be listed again on 11.
11.
11.
Obliged.
Obviously.
Let this case be listed again on
কোন থানা? কোন থানা?
31.
Hey.
You are on interim
No, my lord.
after Bihu
My lord.
on 18th,
My lord.
18 or 19th,
Any day, my lord.
18.
Highly obliged.
My lord, I don't know if it, I pray for legislative accommodation, my lord. Mr. Professor is coming, it may be taken up after 15 minutes. my lord.
My lord, with all respect, my lord. Yeah, my lord, 439 application, my lord, possibly with a difference, my lord. These are all land grab, that land grabbing cases, my lord. And he is an, my lord, office peon in the DC's office. There was, my lord, with all respect, my lord. The prime case is registered by Cyber Police Station, my lord. And Cyber Police Station, when it was registered, my lord, thereafter he was granted the privilege of bail, my lord. I'll come to the affair of this case first, my lord, and thereafter place the papers. Lordship knows more, my lord, he is also possibly aware, my lord, that, my lord, Jammu and Kashmir Chief Minister Uday Chand case, my lord, in a fast forwarding report, if cases are of similar nature, it is to be placed before the court prior to being released on bail. Otherwise, in that authority, my lord, with all respect, my lord, the subsequent cases, my lord, they were set at liberty like habeas corpus, my lord. With all respect, my lord. May I come to the affair of the present case, my lord? That is at, my lord, lordship would kindly have a look at the affair that is at page 15, my lord.
No, before you argue, whether case diary would be required in this case.
My lord,
Law, of course, my lordship is very correct, my lord. In a case of this nature, my lord,
if case diary is required, then we will fix a short date and.
Yes, sir. But my lord, otherwise law is, my lord, they cannot arrest like this, my lord. This is, my lord, abundantly clear, my lord. Can I please, should I please it?
Or.
As your lordship please, yes, my
Let
lord.
us call for a, fix a short date.
Monday, my lord. Monday, he will agree, my lord. Because otherwise also on that count also he will get bail, my lord. He has to. They cannot, my lord.
During your arrest in previous case, you were subsequently shown as arrested.
On the same day, my lord. They were aware. Can I read that authority, my lord? One line it will take, my lord, with all respect, my lord. First is the Uday Chand, and there are several authorities, my lord, supporting that authority of our own High Court, my lord. I'm reading the original one, my lord, the where floodgates were open, my lord. That is in 1983, my lord. Uday Chand and others, my lord. They are the relevant paragraph I'm reading, my lord. Had Mr. So-and-so, so-and-so, so-and-so were enlarged on bail in pursuance of an order passed by this court on March 2, 1981. But they were subsequently arrested for some other offense, alleged to have been committed by them prior to March 2, 1981. Same is the case here. We are quite amazed at this statement And we should have expected that if after the order of bail passed by us, authorities of the state considered it fit to arrest any of the petitioner for any other offense, it was their bounden duty to apprise the court before taking these persons in custody, especially when no disclosure was made to us when we passed the order of bail that the case or cases were under investigation against any of the petitioners. We regret that this elementary courtesy to this court was not shown. We would like to reiterate that the petitioners shall be treated as free citizens in spite of the fact that they have been subsequently arrested, which arrests are clearly contrary to order of the bail passed by this court. So let it be on Monday, my lord. Let him.
Monday, is it possible?
Monday. Yeah.
No, could it be on 9th? 9th?
Mr. B.K. Mahajan, Learned Counsel for the also Mr. D. Das, Learned Additional Public Prosecutor. Considering the nature of the case, perusal of the case diary would be necessary. Hence call for the case diary, fixing 9th.
Not 8th, my lord, 9th he said.
9-1 for case diary.
9th, man. Highly obliged, my lord.
Major loss, 439 and offense 354 B is the only non-variable section, my lord. Arrested on 31st. Then your lordship will find page 17, he is the deputy director of elementary education in Guwahati. And your lordship will find whether it is really 354 B does not come at all. If at all it is assumed to be true, my lord, it comes out 354 A, my lord, which is available. My only prayer at this stage, my lord, your lordship can this poor, my lord. Because October 439, my lord. So this poor, your lord, next Tuesday or Wednesday, my lord, your lord.
Is it
On 11th, below.
third Mr. H.R.A. Chaudhary,
Budvar.
Learned Senior Counsel assisted by
No, just
Mr.
give.
I.U.
I.U. Chaudhary, Learned Counsel for the petitioner. Also Mr. D. Das,
Even last
Learned
name.
Additional
No,
Public
no.
Prosecutor. Call for the case diary.
11, no,
Fixing,
12 last.
12 last.
fixing 11 or 12.
No, my lord, 11, my 12.
11.
Fixing 11
11.
one
Either 10 or
for
11.
case diary. 11.
আপনার অসুবিধা নহ'ব স্যার আপনার অসুবিধা নহ'ব
কি হবে না?
May I please, your lordship, my lord, in this case, I filed a criminal review petition, my lord, for quashing of the orders of item 4.
Motion.
Quashing of
My lord, what happened in this case, if I have to give the backdrop, my lord?
order can be quashed or set aside
Yes, my lord.
with
Because of the fact, my lord, that PW4 deposition is having two versions. One is the certified copy and one is the record in the original, my lord. So now a process was carried out wherein FSL and CFSL was called for, my lord. Report were called for.
no, you tell me the facts from beginning.
My beginning facts is like this, that a 376 case was registered against this accused petitioner and some others, my lord. And the lady who happens to be the victim, my lord, is one Mosomi Das, my lord. So somebody was running a racket of prostitution in Dibrugarh, my lord. So in that event, a case was registered and these two persons were the customers. That's the allegation. Now the case proceeded since 2012, my lord. The case was originally filed, my lord, and thereafter the case proceeded, my lord. Then PW4 was examined as the victim of this case, my lord. She deposed, my lord. And in the meantime, the counsel who was conducting the case on behalf of me has handed over the file, my lord. He was changed, my lord, and the new advocate comes, my lord. He, after going with the brief, my lord, for argument stage, my lord, made the submission, my lord. But it does not tally with the judge because the deposition that is on record is different and the deposition of the certified copy supplied is different. So then it came out that what is the issue, my lord. Then a process was conducted, my lord, whether it is actually the signature of the girl or not. Photostat copies were given, all this.
This deposition of the victim
Victim girl, my lord. I have annexed all this.
on record
Yes, my lord.
is different from the certified copy.
Yes,
which was
provided to us. That's the issue, my lord. Now when they're in the certified copy, there is no involvement of the accused. Nothing has been uttered regarding this accused petitioner. So argument was advanced. But when the trial court took up the matter, trial court was also mesmerized. How can it be? When it is on record, it is saying this way. Then, my lord, the court carried out an exercise.
Trial court.
Yes, trial court, my lord, calling for the FSL report, state forensic science laboratory report. So everything in the certified copy and all these things were heard, my lord. Then it was again not satisfied. The court sent it to for Central Forensic Science Laboratory. There also the report came that it is the girl who has actually made. Because even the signature given by the PO, my lord, was also sent for verification. That also says that it is of that presiding officer, my lord. So now the judge says in the impugn order, my lord, on 31/5/23, my lord, saying that this anybody can do it. That cannot be, my lord, with all respect to your lordship. So all this I have annexed it also, if your lordship will see. The impugn order,
No,
my lord.
what is the, where is the impugn order?
My lord, that is at page, my lord, is dated 31/5, page 45, my annexus 7, my lord.
Page 35.
Yeah, 45, my lord. Shall I read?
This order is passed on some petition filed by.
Yes, yes. Because we have to cross-examine him, my lord.
Oh, for summoning again.
Yes, my lord.
PW4.
Because of the fact, my lord, in the original deposition, there is an allegation and materials against me that I have raped her or something like that, my lord. But in the deposition, I was not there. So the counsel, new counsel went for argument, but when it was brought to the notice, he immediately filed a petition. Though it should have been, ought to have been 311, my lord, but the petition was filed under 137 and 138 of the Evidence Act, my lord. That is also there, my lord. That is on 14/5.
Okay.
So if now the trial proceed without giving me a chance to cross-examine again, my lord, I'll have to brought it on record, my lord, because there are two versions now emerging, my lord. Now, actually, my lord, with all respect, I'll submit, my lord, the court should also take it up in the administrative side to see that how this could happen, my lord. It may be the tip of the iceberg also, we don't know, my lord. We also want that the guilty should be brought to the. I have annexed both the deposition, your lordship. The certified copy as well as there. These are marked as annexure 1 and 2, my lord.
No, this is a long order. What it says?
My lord.
The impugn order is a long order.
Non.
Long.
No. But the wrong is that, my lord, that without taking it on record, my lord, the true facts, now when two versions are available, certified copies is secondary evidence. Primary evidence is on the record. FSL says that no, this is also correct. The copy that has been furnished to us. All these were done in the process, my lord. I have got the original certified copy also. So without coming to the conclusion first, the which one is correct, my lord, the court will pass the judgment on the basis of that, wherein I have not cross-examined it. Because the certified copy, when it was provided, there is no.
In the original deposition, which is there on record.
Yes.
Whether she was shown to have been cross-examined.
Yes, man, absolutely.
Cross-examination is there.
Yes, yes, my lord. Cross-examine implicating and incriminating me. But in the certified copy provided to me, those things are not there.
Now the trial court will go by the original which is there on
That
record.
is all there, my lord. But what about the certified copy provided? to
That
me,
is
sir?
the subject matter of an
Yes, my lord. When, my
separate
lord, that
inquiry.
subject matter of trial itself, my lord. That exercise is to be concluded, my lord, because CFSL report is there, FSL report is there. So
Which-
all these
what-
negates the court's records, my lord. That I have annexed it, my lord. Because it is the person who has written it has signed it. And the victim was asked to supply her specimen writing and all, she has not come forward to provide.
For what purpose FSL was
All this to be written, whether it
to
was her,
verify-
whether, yes,
to
her
verify
signature.
whether the
Yeah,
certified
whether-
copy,
Absolutely.
certified copy is a photostat copy.
Yeah, but in the original also, my lord. What does the original says, my lord?
whether original is available.
Yes, my lord,
of
that's why the
this-
record may be called for, that's why I'm submitting, my lord. Your lordship will have a I view. my
What
lord.
is the status of the case?
Argument, it is fixed, my lord.
Since long it is fixed only for argument.
Yes, my lord, yes, my lord. 31/5 is the order impugned, my lord. And now, due to the process, my lord, it has come to be fixed on, I'll give the date. 24/1/24, my lord.
No.
Because we also want that the guilty should be brought to the book, my lord. If my client has done it, he should be punished to the highest, my lord. With all respect, because I say so, because we are part of the parcel of the
No,
judicial
since
process,
last
my lord.
June, why argument were not heard?
My lord, because of the
There-
process, my lord, I was not in the trial court. This is from.
There was
Digrugarh,
no
my lord.
stay.
No, there was no stay.
There was no stay.
Yeah.
Now, what is the status now?
Now, next date is fixed 24/1 for final argument. In view of this order 31/5/23, which is under challenge. Because if the whole exercise goes and tomorrow it comes out that the record has been manipulated because somebody wants to see me, I am punished at all costs. It may be the other way around also, man. So at this stage, my lord, let notice go to the OP2 also, to the state also, call for case record. In this case, it will be better to call for the case record, my lord, to have a naked eye view as to what's happening, my lord.
And let the trial proceed there.
But thereafter, my lord, immediately within the short date, it may be fixed, my lord. We'll dispose of the matter. I put it on
It
record.
is
my lord.
unlikely in High Court.
No, my lord, your lordship will take it as part, no issue for me. But the truth should come out. Now, who has manipulated and who has doctored the document? Somebody interested to see that I am convicted by hope of proof. The records of the court may also be tampered with, my lord, we never know. The CFSL report say otherwise, the FSL says otherwise.
What petition you have filed?
For recalling of PW4, my lord.
Now, on what ground it was rejected?
Because a lot of time has gone, it is in that impugned order, my lord. The petition was filed jointly by accused Dilip Kumar Agarwal and Santanu Tamuli under 137, 138 CRPC, praying for upwarding them, their engaged advocate.
What is
and-
137, 138?
My lord, that is for further cross-examination and re-cross-examination. My lord, it ought to have been under 311, I do agree and admit, but somehow wrong quoting of section itself will not be a ground to throw out the petition, my lord. The contents is that way, my lord.
CRPC?
Yeah, no,
138.
137 of the Evidence Act, my lord.
But it is mentioned CRPC.
CRPC 311, my lord.
But
For
the
recalling of the
order
witness.
sheet,
My lord.
what is mentioned in the order sheet?
In the order sheet, it is 137 and 138 because we have filed it that way, my lord.
Of the CRPC it is.
No, no, no. Of the CRPC.
It is again wrongly mentioned.
Absolutely. Here it is written that way. I'll
Yes,
just check it,
Mr.
my lord.
Das, what is to be done? Because argument is already delayed.
Delayed.
If we issue notice and give a stay, there is every likelihood that it will be delayed further. But the
No, my lord, what I
Question
submit,
is-
subject to what my learned friend says. Court is bound to act on the original, that is primary evidence available on records. Court cannot go by
no, you are aggrieved not with that. You are aggrieved with non-recalling of
Non-recalling, my lord.
PW.
My lord, let the record be there, my lord, but that exercise is to be carried out. My lord, in my petition, it was written, petition for re-examination under section 137 and 138 of PW4. Honorable court, my lord, somehow wrote CRPC, my lord.
Okay.
Because 137, 138 will be for the evidence act, that is recalling of the witnesses, my lord. But petition ought to have been, according to me, under 311, my lord. 137 is the examination in chief, cross-examination and re-examination. Then 138 is the order of examination. Though this way court moves, my lord. But unfortunately, the court also put it as CRPC, my lord, which is not correct also. It ought to have been 311 CRPC for just decision of the case. So let the witness be recalled, my lord, we will take our call, my lord, accordingly. Because she will depose whatever it is stated, but
Heard, Mr. Z. Yes, anything?
So far recalling is concerned, as it appears from page 29, she has been cross-examined at length, by, for all the.
No, you want to recall only for the,
PW4, my lord.
only for the purpose of
Putting it on
verifying
record, my
the
lord.
whether certificate.
Absolutely. That much so, my lord. And everything has been spelled out in my petition also, my lord.
If that recalling is allowed,
Yes, my lord. So all thing will be crystal clear.
can you make your submission on
The
whether?
thing is that, in a number of cases, apex court has, negated the prayer, such prayer on
Okay,
flimsy
not
ground.
rejected.
It is not that he was not given opportunity to cross-examine the PW4.
No. I
He
want
has
your-
cross-examined. Now, whether there is some anomaly in regard to certificate copy and original evidence on record, that will be a subject matter of different case. If somebody has forced it, the law will follow, my lord. But court has to go by the original evidence on record.
But the whole case is stated at Annexure 3, page 33. My learned friend will take the kind trouble to read it, my lord. Everything has been spelled out there, my lord.
No, what I,
Yes. Kindly see page 30.
their case is that the
Victim
deposition available on record and deposition
provided.
provided to
Understood.
them in certified copy are different. In record, he has been implicated. In the certified copy, he has been
No.
exonerated. So they want to cross-examine.
Yes.
As because the certified copy is also found to be genuine copy by FSL report
Absolutely.
as submitted. I have not.
No, it's on the record, my lord. I can show it.
So
I
they
can-
want to cross-examine that aspect.
Everything will be settled.
So you have to make your submission whether this can be allowed. If this can be allowed, we can dispose it off at
Yes, madam.
the motion stage without
Going through
giving
it.
any,
Waiting for the record.
waiting for record. We'll
That
fix
much
it.
chance will be given to me.
You go through the record. Go through the impugn order.
Yes, I've gone through.
Impugn order, whether that can be allowed or not. On that, you make your submission.
I have objection to that, because the records are available. My lord, it was open for them also, my lord. It is not that
No,
only.
on what ground the trial court has rejected their prayer? What
Because
was
it
the-
was much time has been consumed, this and that, my lord. But this petition was filed on 14/5/15, my recalling petition. And the impugn order has been passed in 23. So it is the court's order. Court took
Why
it
so delay?
Because of these reports, my lord, not coming, the lady not coming to giving her specimen writing, not providing the documents as sought for by the court. All thing is written, my lord. Then why do you are objecting? Let them come. Everything will be sorted out, my lord. Everything will be crystal clear. Once she takes the witness box, I will also have nothing to say. The court also admits at page 48 that the certified copy and all official document mistake has some reveals that some mistake has occurred. So that needs to be corrected, my lord. With a mistake of facts, a person cannot.
No,
be
you can
sent to court.
obtain a fresh certified copy.
My lord, we'll all do that, my lord, but provided we get the opportunity to cross-examine PW4, my lord, because that petition is not an afterthought. It was immediately filed on 14/5/15 when the new council took the brief from the earlier council. And the court took more than 7 years to pass the impugn order, my lord. It is not because of me, my lord. Court after 7 years passes the order, my lord. At page 48, if your lordship will kindly look into it, my lord.
After 7 years, court has passed on.
Yes. That is no fault and no act has been attributed against me. It is because of the FSL report was in favor, my lord, of the accused. So the court did not agree, wanted to carry out an exercise with the CFSL. That was also carried out. But the lady victim doesn't come in, gives the documents as sought for.
Okay, heard Mr. Z. Kumar, learned senior counsel assisted by Mr. B. Talukdar, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed for setting aside the order dated 31/5/2023, passed by learned additional sessions Judge Dibrugarh in sessions case number 143/2009, whereby the prayer of the present petitioner for recalling the PW4 was rejected. Recalling the PW4 for recross examination was rejected by the learned trial court. Learned counsel for the petitioner has submitted that in the sessions case number 143/2009, the present petitioners are facing trial for charge under section.
My lord. Or 376. My lord, it's in the cost title page, but 376 and one more section.
376.
Well, I'm just giving, my lord. And of the Immoral Activities Act, my lord. Section 5, my lord. I'll give it, my lord, just a minute. 376, 366A
/366A
and section 5 and 6 of the Immoral Trafficking
and section 5
Prevention
and
Act.
6 of the Immoral Trafficking Prevention Act. Where have you narrated that PW4's deposition is found to be?
My lord, your lordship will kindly come to page
It is submitted by
page 48, my lord.
learned counsel for the petitioner.
By
that
this petition, the learned has pointed out that it has come to her knowledge after going through the deposition of victim, which is available in the case record, the certified copy of the
that
deposition of the
the
victim
petitioner
to office is different. So some mistake has occurred. Petition PP insert saying, my lord.
learned senior counsel for the petitioner has submitted that on 13/5/2015, the petitioner's counsel had filed petition number 239/2015 before the learned trial court, praying for recalling of the PW4, who is the victim, for the purpose of the cross-examination on the ground to verify the fact that the original testimony of the victim does not corroborate with the certified copy of the testimony furnished to the present petitioner. Learned senior counsel for the petitioner has also submitted that the discrepancy regarding the discrepancy in the certified copy with that of the original testimony of the PW4 is also admitted by learned trial court. And to verify the same, the certified copy was also sent to the forensic laboratory, wherein it was confirmed that the signatures in the certified copy of the victim as well as of the presiding officers were of the PW4 as well as of the presiding officer. Learned senior counsel for the petitioner has further submitted that if the petitioner is not allowed to cross-examine the PW4 to verify Why you want to,
My lord, to verify it, my lord, and in one case there is no material, in one case she has stated they have raped me, and in
verify-
one case they have not raped me.
to verify the genuineness or otherwise
Yes, my lord.
of the testimony which is available
It is
on
the
record, the
Page two.
petitioner would be
Page
prejudiced.
23.
Stop.
Page 29, and sorry, page 31.
Considering the submissions made by learned counsel for the petitioner,
No, it is. Motogram. It is a fact that accused is, did not
let,
have
let
intercourse
the
with me.
notices be
আমার
issued to
copy
the respondents
Is I say accused Dilip Bhagwan
As-
forcibly sexual intercourse with me
as
and found
the-
not guilty. এইসব কেনেকুৱা হ'ব? এইটো চব পঠাইছো।
as the additional public prosecutor has appeared for respondent number one.
সবই করে।
No formal notice need to be issued to respondent number one. As regards respondent number two is concerned, no, why respondent number two is required here?
My lord, under 482, my lord, nowadays we have to make the victim a party, my lord. Otherwise not required, my lord, but formality is to comply. Otherwise the office will not pass it, my lord.
No, here you are against an judicial order.
But we have, but the office will object it if under 482, the victim is not made a party, my lord.
Issue
In a rape
notice,
case, my lord.
issue notice to the respondent number two as per the,
Circular decision.
as per the procedure laid down by division
482,
bench of
yeah,
this
appeal.
court in Deepak Naik versus
That's what
State of
it
Assam.
is.
And call for the scan copy of the case record of
Original will be required in this case, my lord.
then the matter would be automatically state, there will be delay.
My lord, we,
Well, let a status report be called for from the. child
No,
court.
status report would not help. We have to see the
by
implication.
the naked eyes, my lord.
Call for the,
But
call for,
unless it is state, my lord, his petition will become infructuous. If
That's
it
why
is
stay
fixed,
will be required.
just stays to be clear. Call for the case record of. Call for the case record of sessions case number 143/2009. From the Court of Learned Additional Sessions Judge.
Dibrugarh in session case number 143 of 2000.
In the meanwhile, till further orders, the further proceeding of sessions case number 143/2009 shall be kept in abeyance.
Right.
Let this matter be listed after
Receipt of the case record. Yes, your lordship.
after 3 weeks.
Much obliged.
Notices returnable after 3 weeks.
একটু টাইম বলতাম ডিলি হয়ে গেল
কি কৰি আছিল তাতে কি কৰি আছিল? সেইটোৱে নেকি? কোনটো?
No, 14 PS a law.
on the merit.
Who was with?
Oh, 14.
He was there.
Oh, yes.
14 he was there.
I have seen it, my lord. LCR to do so. Setia.
The
LCR.
only point that was that he has.
What was the
only
material
ticket
against
was
him?
found with the other main accused persons. This person was in the train and the ticket was found with the others. Now that connection with regard to 29, how the connection will come?
My lord, so also we kindly see the statement of co-accused. This is an reverse case, my lord. That is the only material. Admittedly, from his position, it was not recovered. But what happened, your lordship will find there. Your favor to delivery.
Statement of?
Thank you.
Yeah, he Actually, from these two accused persons' possession, my lord, the contraband was recovered. Lucky man.
Would like to contact us.
Record now.
No point in this.
Co-accused has implicated.
Lordship.
Co-accused has given implicating statement.
But only on the statement of co-accused, your lordship, the under Tufan Singh. I don't think that is a justified only on that ground, your lord. Even the charge sheet, nowhere there is any implication. In the,
What
if
is the
that has
stage?
been
What
done,
is, what is the stage now of this?
stage, your lordship, not even, CC has not even, till now, 401 days, no charges were not filled.
Charge is not from.
So apart from co-accused statement, nothing is there. Heard Mr. Y.S. Mannan, learned counsel for the petitioner.
But yet I strongly oppose the bill.
Also heard Mr. D. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Mohammad Wazirur Rahman, who has been detained behind the bars since 19/11/2022, within bracket 411 days, for last 411 days, in connection with what is the NDPS case number?
NDPS case number 60/22.
In connection with NDPS case number 60/2023,
Arising out of
pending in the court,
GRP case
pending
number
in the court of
163/2022.
pending in the court of learned Sessions Judge Kamrup, Metro. The gist of accusation in this case is that on 19/11/2022, one Posheshwar Gogoi had lodged an FIR before the officer in charge of Guwahati GRPS, inter alia, alleging that during that on 19/11/2022, during the checking of Rajdhani Express, within brackets, train number 12423, which was stationed at platform number 1 of Guwahati railway station. The informant and his and other police personnel of GRP police found the present petitioner in coach number B1 of the said train without any valid railway ticket. And on inquiry, he told that his ticket is with other two passengers. Thereafter, the other two passengers shown by the present petitioners were also interrogated and they were searched. And on search of their body, two packets containing suspected heroin were found concealed in the lower abdomen portion of the other two persons shown by the present petitioner. The name of the said persons are number one, Ahud Ahmad and Ubaydur Rahman. The total weight of the contraband seized from the co-accused was how much weight?
500, 1 kg
1 kg of suspected heroin.
together.
On receipt of the said FIR, Guwahati GRPS case number 163/2022 was registered and investigation was initiated. And after completion of investigation, charge sheet was laid against the present petitioners along with two other co-accused persons under section 21C/29 of the NDPS Act, 1985. Learned counsel for the petitioner has submitted that the bare perusal of the FIR would show that nothing was recovered from the possession of the present petitioner, and the recovery of seized heroin was made only from the co-accused persons. It is also submitted by learned counsel for the petitioner that in the charge sheet also nothing specific has been mentioned against the present petitioner, and there is no material to show how he had conspired along with the co-accused in the offense alleged in the FIR. The petitioner, therefore, the learned counsel for the petitioner, therefore submits that no offense under section 21C/29 of the NDPS Act is made out against the present petitioner, and therefore the embargo of section 37 is not applicable in this case. On the other hand, learned additional public prosecutor has produced the case diary of GRPS case number.
No, scan copy has come in.
On the other hand, after perusing the scan copy of the NDPS case number 60/2023, which was called for in connection with this case, learned additional public prosecutor has submitted that the co-accused Ahud Ahmed has implicated Ahud Ahmed as well as Ubaydur Rahman have implicated the present petitioner and have stated that it is the present petitioner who fitted the two packets of heroin on the vest of the other co-accused persons from whom the seized contraband was recovered. And on that, it is therefore, learned additional public prosecutor has therefore strongly opposed the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, and have perused the materials on the record, including the scan copy of the case record of NDPS case number 60/2023. on perusal of the record, it appears that nothing was recovered from the possession of the present petitioner. And the recovery was made only from the co-accused who have concealed the seized contraband inside their bodies attached to their abdomen. It also appears that the only material available on record against the present petitioner is the statement of the co-accused recorded during investigation. And apart from that statement, there is nothing available against the present petitioner to implicate him under section 21C/29 of the NDPS Act. The apex court in the case of Tufan Singh versus State of Tamil Nadu, reported in 2013-16 SCC 31, has observed that the statement of co-accused. Where is you have Tufan Singh with you?
Sorry, Lordship, I did not bring.
Has observed that statement of co-accused recorded under section 67 of the NDPS Act may not be
Mobile on now. Ulai, Tufan Singh photo. Citation per se. Citation is 2021 4 SCC 1.
Citation is
2021 4 SCC 1. Tufan Singh.
okay. Citation 2021 4 SCC. You have Tufan Singh with you.
No, I don't have. I'll ask her to get a copy of that.
We're getting one.
Nita, last line.
Full design. Full design. No. Yes.
May not be used against the co-accused. Used as an evidence against, is not admissible as an evidence against the co-accused.
2020.
No, this has to be verified.
I think that is not correct.
This is wrong.
That is not correct. It should be 2020, not 20. I am telling him. Verify karo na. Mobile line hit maro. I don't think that is correct. Okay, verify karo.
Tufan Singh is old case.
It is, I think, 2020, I think.
Considering the fact that in the present, except the statement of the co-accused, there is nothing available on record to implicate the present petitioner under section 21C/29 of the NDPS Act. Hence, for the limited purpose of the consideration of the instant bail application, this court is of the view that there is reasonable ground to believe that the present petitioner is not guilty of the offense alleged in this case. And is there any previous material to show your previous
No,
involvement?
no, there is nothing here.
It's in the case, I did not find such entry.
Stop. Further, there is also no material to show that the present petitioner has indulged in similar offense on any earlier occasion. Therefore, there is no material to show that he is likely to commit offense if he is released on bail. In view of above, the present petitioner is hereby allowed to go on bail of rupees
Yes.
50,000 with two sureties of like amount.
One should be government employee.
Two sureties of like amount. The one of whom should be a government servant with following conditions: that the petitioner shall cooperate in the trial of NDPS case number 60/2023, which is pending before the Court of Learned Additional Sessions Judge. Which court it is pending?
It is pending before the Court of District and Session Judge Kamrup M.
District and Session Judge Kamrup Metro. The petitioner shall regularly appear before the Learned Trial Court as and when so required by the Learned Trial Court. And he shall not leave the jurisdiction of the Learned Trial Court without prior permission of the trial court. The petitioner shall not directly or indirectly make any inducement, threat or promise. The petitioner shall not commit any offense similar to one for which he has been accused of in the present case while he is on bail. With above observation, this bail application is hereby disposed of.
Not so. It is 2021 4 SCC 1, but the decision was in October 2020. But reported in 2021 4 SCC 1. I have verified.
2021 4 SCC 1.
Yes. Much appreciated.
FIR is a page 9 charge-sheet matter. Look at it. LC has come. Page 9 is the FIR.
It is NDPS again.
No, Lord.
POCSO.
376, 3 and 4 of POCSO.
What is the stage of trial?
Most of the vital witnesses are over.
Victim has been examined.
Yes, yes. It is already page 13. Lord, you may see the lower court
Victim
class
has been
paragraph.
There,
Once,
yes,
once
there is
before-
one report dated 13 of November. Out of 11, 8 examined. Only IO and 2 more is to be examined.
164 is also taken.
Yes, what is your submission?
Lordship, NCR is there, otherwise in medical, though it's done after 4 days of the incident, nothing in this there in the page 14 and 15 medical report. There is delay also. A delay of 3 days in filing the FIR. And moreover, all the vital witnesses are over, therefore no point keeping the petition in custody now. He has to come again after judgment.
Yes.
My lord, here, my lord, as per the statement of the girl, my lord, she stated her age is 14 years, but she said her date of birth is 22nd of February 2010. Incident occurred on, my lord, January, 15 January 2023. My lord, not even 13 years complete, around 13 years, my lord. And I have flag marked the 164. As well as her evidence, my lord, as PW1, my lord, victim. My lord, clearly implicated, my lord, and doctor evidence PW8 is the doctor. As per the doctor evidence, medical done on 19/1, incident on 15/1. So after 4 days. as per Dr. Evidence, no recent physical, that is there, my lord, but age is 15 to 12 to 15 years. So it is around 13, my lord, as per date of birth.
Medical
And,
report is 14.
Yes.
No, not on merit. There are grounds. Now the question is whether
Other.
he will abscond. If he,
My lord,
what is the fear if he is released on bail?
only, my lord, I am praying for, my lord, directly for spiritual, because only IO and 1 or 2 is left. Already, it's a case of, my lord, this year, already, my lord, spirit trial has been done. Until that, my lord, out of 11, 8 witnesses already examined, my lord. So, my lord, at this stage, my lord, let the IO maybe, and immediately after that.
Lordship, may I please? Lordship, I just submit that the punishment should start after conviction, Lordship. Otherwise, Lordship, evidences have been taken, no chance of tempering any evidence. And witnesses have been examined, vital witnesses.
The informant is also appearing.
My lord, he is okay.
What is your submission? Because whether informant is opposing.
Opposing or
Informant.
informant, so what do you want?
No, Mr. Parashar. Now, why are you opposing the bail? Though he may be convicted, ultimately he may be convicted. At this stage, one ground is that if there is a apprehension that he may evade the course of justice,
My lord.
then that may be a strong ground for refusal of bail. But is there any indication?
Otherwise, my lord, the girl, my victim girl, a 13 years girl, how?
No, he will be,
Directly, my lord,
if it
yes.
is,
My lord, yes.
heard Mr. P.J. Dutta, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor, as well as Mr. What is your name?
I'm on behalf of K.U. Ahmed, Lordship.
Heard Mr. K.U. Ahmed, learned counsel for the respondent. This application under section 439 of the Code of Criminal Procedure, 1973.
My lord, sorry, my lord, one thing only, my lord, PW2 is the father of the victim. In his statement, he stated that on the next day, he my lord, accused, my lord, attacked the father of the girl and give him a blow on his chest. That is also, my lord, statement of the, my lord, PW2, the father of the victim. Already over, but in his statement, it is recorded that he attacked the.
In the investigation stage, maybe, I don't know, Lordship.
Yes, that is my statement of the PW2.
But you may put any condition, I will not explore. I will face that ultimate result. If I might appeal, but I will not explore.
What was the last? Has been filed by the petitioner Akash Munda, who has been detained behind the bars since when you are behind the bar?
For 19/1/2023, page 11.
Since 19/1/2023 for last 262 days in connection with
351 days.
For last 351 days in connection with special within bracket P case number 27/23 pending before the court of learned. Which court it is pending?
Sorry.
Trial is pending before which court?
Sibsagar special court, page 11, Lordship.
Special.
Special Judge Foxo, the Honorable Special Judge
Special
Foxo.
Judge Foxo Sibsagar. The petitioner is facing trial under section. Where is the charge?
376(3) and section 4 POCSO Act, please.
Charge under section 376 slash section 4 of the POCSO Act 2012. And it is submitted by learned, stop. It is submitted by learned counsel for the petitioner that out of the 11 listed witnesses, 9 witnesses,
Eight.
8 witnesses have already been examined, including the victim girl as well as the first informant. Only the
IO
IO
and
and
two other, my lord.
2 other witnesses are there to be examined. Learned counsel for the petitioner has submitted that the petitioner would would cooperate in the remaining part of the trial, and there is no justification at this stage for keeping the present petitioner behind the bars, as he is willing to face the trial. On the other hand, learned additional public prosecutor submits oppose the grant of bail to the present petitioner on the ground that the victim was of only 13 years of age when the alleged offense was committed. And there are serious implicating materials against the present petitioner. I have gone through the scanned copy of the case record of Special P POCSO case number 27/2023, which was called for in connection with this case, and have considered the submissions made by learned counsel for both the sides. The petitioner has been detained behind the bar since last 351 days. And already the victim girl and the first informant have been examined. Hence, and there is nothing on record to show that the petitioner would abscond or evade the course of justice if he is enlarged on bail. Hence, this court is of considered opinion that if the petitioner cooperates in the remaining portion of the trial, his custodial detention may not be required for the purpose of fair completion of the trial. In view of above, the petitioner, namely Akash Munda, is hereby allowed to go on bail of ₹30,000 with one surety of like amount, subject to satisfaction of learned Special Judge POCSO Sibsagar, with following conditions. Number 1, the petitioner shall continue to appear before the trial court on each and every date fixed by the learned trial court, and shall not leave the jurisdiction of the trial court without prior leave of the trial court. The petitioner shall not make any inducement, threat, or promise to any witnesses of the case so as to dissuade them from making any disclosure against the petitioner in the trial pending in the trial of Special P case number 27/2020. With above observation, this bail is disposed of.
Item 23 and 24.
May I please, your lordship, on last occasion, CD was called for lordship. And
In this case, my lord, on earlier occasion, CD was there. But some petitioners have filed bail petition in the sessions court also. As a result, yes, on 27/12/23, the case was fixed there. And that is why CD from our office. It was taken by the IO and it has been submitted before the learned court below. On 27th, though it was fixed on the 27th, on that day, it was not disposed of. On 3rd January, it was again fixed. But on 3rd January also, it is not disposed of. Now, one important thing is that, Milord, as per instruction received by me, the petitioner Anand Dev, item number 24, Milord.
24. We are taking up 23 now.
No, 23, all right, Milord.
Arising out of same page.
Yes,
Okay.
Anand, he has also filed one bail petition there. His petition is also pending there. Or how that is, when he on affidavit, please, when on affidavit he has said no bail petition is pending in any other court. Now, 3 persons, my lord, according to my instruction received by me, 3 persons filed bail petition: Shubham Sarkar, Anand Dev, and Babul Das. Those are pending before the learned additional sessions 2 and 3. One is before one court and other 2 is before another court. So let a report be called for in respect of this Anand Dev, my lord. How he would file while the matter is seized with, when this honorable court is seized with the matter, how could he approach a subordinate court?
No, whether there in the affidavit they have mentioned
Yes, exactly mentioned it is.
before.
I have
before the
examined the affidavit. Your lordship may kindly see page 6 of his petition. This is
was
item number
filed-
24.
This was filed,
Lordship,
which was filed
this was filed on lordship, it was filed earlier, lordship.
earlier. So there they have to mention that already.
Yes,
There
lordship.
they
That
might
is why,
have-
that is why
they
I
might have
submit,
considered-
let a report be called for, my lord. Because in para 10, he has categorically stated
in-
that no other bail petition has been filed.
In item number 23. Our CD would be required.
Lordship.
Serial will be required.
Heard Ms. S. Kanon Go, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor, who submits that though the case diary was earlier available with them, however, same has been sent back to the learned trial court as some of the co-accused persons have preferred bail application before the learned trial court in which CD was called for. Hence, learned additional public prosecutor prays for some more time on producing the case diary. The prayer is allowed. Let this case be listed again
Let it be on 19th, my lord.
on 19-1 for case diary. In item number 24. Heard Ms. S. Kanon Go, learned counsel for the petitioner as well as Mr. D. Das, learned additional public prosecutor, who submits that the case diary which was available before this court on earlier occasion has been sent back to the trial court as some of the co-accused have preferred the bail application before the trial court and hence prays for some more time for producing the case diary. Prayer is allowed. Learned additional public prosecutor has also submitted that he has been informed that the present petitioner has also preferred another bail application before the learned trial court during the pendency of the instant bail application. And therefore he prays for calling for a report from the learned trial court as to whether the present petitioner has disclosed the fact of pendency of the instant bail petition before the learned trial court or not, while preferring the bail petition before the said court. Let a report be called for from the learned trial court.
Along with a copy of the bail petition, his bail petition.
Along with a photocopy of the bail petition preferred by the present petitioner before the learned trial court.
If any.
Let this case be again listed on
19-1.
19-1.
Report.
Item 27.
May I read the lordship?
Charge sheet submitted, my lord. Nagar Barana.
It is beyond the bar, my lord, last 50 days, my lord. Allegation, my lord, 379, my lord.
But now you
Uh,
have to go.
Charge sheet submitted on, my lord, 30th of November.
13th of November.
30th of November.
Heard,
There
Mr.
we don't have the
Z.
instruction.
Hussain,
M. Hawk.
M. Hawk, learned counsel for the petitioner. Also, Mr. K. K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
CS number 111/23, 111/23, dated 30/11/23.
in view of the fact of laying of the charge sheet. This bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
Bless me.
On मतलब third मतलब already this मतलब had this case मतलब search was done on around 9 p.m. मतलब, and before that मतलब he was taken into custody. Whether there is an authority letter or not मतलब, I have checked the मतलब LCR मतलब. There is a note of the IO. I have flag mark blue flag with a hash mark मतलब. In the note मतलब, he has mentioned that there is a authority letter from the additional deputy commissioner of police central and that flag. But that letter I have not found. Maybe in the Malkhana or maybe, but in the LCR it is not come. But in the note there is a letter, written letter, authority letter from the ADCP. So Malat, we has to be informed within 72 hours. So already it is a inform and with the authority letter Malat.
No, his ground is different. His ground is in 42,
Yes.
42 proviso.
Yes. Malat,
That whenever there is a search after sunset, then you have to mention the reasons why.
Reasons? Yes, Malat, that.
Why it was done after the sunset and before sunset.
Second proviso. Further reason to believe that.
Little reason I have not found.
The grounds have to be given why. Permission is for search and seizure is fine. (42) second provision. It's not 72 hours to hold.
Where is the violation in your case? What has been violated?
Your lordship. Here, your lordship, it is a charge sheet under section 21C and 29 NDPS. The amount of heroin recovered was 282 grams.
Okay.
And
no, your submission was not complete. You were to place 3 judgments.
Actually, yes, this judgments. I thought your lordship wanted to know about the facts. These 3 judgments, your lordship. First,
No facts. Okay, facts are.
Facts. I'm not going on the facts. Specific 37.
What has been violated? What is your submission?
My
Which
submission was
provision?
basically the violation was with regard to 42 proviso wherein this particular search was conducted after sunset, before sunrise, after 9 PM, without the authority, your lordship, I think it's in writing, it has not been disclosed, anything in writing, why it has been done.
Without recording the grounds.
According, that is the grounds of doing it during that period. And second part, your lordship, was here, there was one issue that the person may fled away. On that ground, it can be done, but here is the case where he was already in custody. Thereafter, the search was done. So, your lordship, the recording the reasons or the grounds for doing the search at the period of time after sunset, before sunrise, is against the provisions of 42. And 42, your lordship, is mandatory. That, your lordship, I have already given 3 judgments on that. And subsequently,
Let
your
us,
lordship,
let us see those judgments.
yes. First, your lordship would like to see the 42 judgment. Yes.
State of Rajasthan,
First, I have given your lordship 3 judgments.
Jagraj Singh.
One is, your lordship, the
No, read para 14 of the Jagraj Singh.
Jagraj Singh. Jagraj Singh, you take from preliminary, will you? Just a moment, your lordship, I have mixed up all the judgments. Take it as right. Take it as subsequent. Take it as subsequent. Take it Gupta Singh. Jagraj Singh to put very.
If there is an authorization, then whether 42(2) is applicable. Or still he has to mention the reasons for.
The authorization will come subsequent. Because when he will, your lordship, record the reasons for doing it between sunrise and sunset, and with then the next proviso says he'll have to send it to the higher authority within 70 hours. That is the next proviso. If your lordship reads that. First, second proviso, your lordship, provided further that if the officer has reason to
No,
believe.
Mr. Manan, my query is, if before conducting the search,
Yes.
authorization is there,
Yes.
they first obtain the authorization and thereafter conduct the search. Then whether 42(2) would be required.
But
Then also,
I think it is because here the specifically it has been given
that I want to know.
sunrise and sunset. Sunrise and sunset. Because I'm not on the other part, your lordship. Basically, what happens when there is an authorization for search and seizure, your lordship. But whether that authorization is for between sunrise and sunset. And for sunrise and sunset, he'll have to give a detailed reason. And whether that reason has been given. If it has been given and authorization has been given, then I don't have. But I don't think so. I mean, from the records which he said, there is authorization is given for search and seizure, but there is no reasons given for sunrise and sunset to be done between that period. Because the person was already in custody. Because initially he filed an FIR, then went to the place where he was taken into custody. Then these persons were taken, this person was taken.
Yes,
to
Mr.
the-
Parashar, what is
Malak-
required is,
Provided, I am reading again, my lord, for all
What?
understanding, my lord, provided further that if such officer has reasons to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of the evidence or facilitated to escape of an offender, he may enter search. So if
read
cannot be
complete,
obtained,
complete.
search.
Then
The building, convenience of enclosed place at any time between sunset and sunrise after recording the grounds of
this belief.
this belief.
So this ground has to be given to the before authorization. That is what it reads. Because authorization, he can apply for the authorization after giving the points, the ground, that this is the ground. I am entitled to be authorized to do the search between sunrise and sunset. Sorry, sunset and sunrise. So according to me. And oh, it will have this. Right.
Again, whether grounds to be recorded on.
What those judgments which you have cited says.
The judgment that initially 42, I said, your lordship, with regard to, your lordship has pointed out para 14 of Jagrasi. It says that the same it has quoted that. The scheme indicates that in event the search has to be made between sunset and sunrise, the warrant would be necessary unless officer has reason to believe that the search warrant or authorization cannot be obtained without affording the opportunity for escape of the officer, who is ground of his belief has to be recorded. Again, that has been given. In the present case, there is no case that ground for belief as contemplated by proviso to so and so was ever recorded by the so and so. Para 14 of the Jagraj Singh, which your lordship has. This is the ground I am trying. So he has to give a reason that yes, I am going to search it between sunset and sunrise. So kindly give me the authorization. These are the grounds on the basis of which I am going to do the search. That is mine.
No,
And
my
then-
query is whether authorization for conducting search during night, for obtaining that authorization, you have to also mention the ground.
Yes, that's what I am trying. Because according to
It
the
says that if you
statute,
cannot obtain authorization, then you have to mention grounds. It says, but whether it also says that for obtaining authorization also, you have to mention the grounds why you
Want to-
intend to conduct search after sunset.
sunset and sunrise part, your lordship, that has been dealt with in this paragraph. So with regard to the other part, authorization is good enough, nothing required. But when it comes to sunrise and sunset, this is why this particular word has been put in, that you have to give your reasons. Whom he will give the reasons, your lordship? To the authorizing officer, your lordship, obviously. He cannot give it to the accused, your lordship, obviously not. So why he has been given that duty? That these are the grounds I want to do the search. You have authorized me to do the search, but I want to do the search on these grounds. This is the authorization letter, giving the specific grounds. You just get an authorization letter that can put the after sunset, oh sorry, after sunrise. After sunrise or during the course of any other search, it is not required. It is only required if it is done after sunset, before sunrise. And that is why I am trying to point out that this period, if you're, why has been incorporated in the statute, that this period, if you do it in the authorization, you have to indicate that. The authorization letter should be there should be some indication with regard to the grounds for doing it at night. In the daytime, it is not required at all. Just authorization will do. Then fine. But this part has been incorporated for what reason? Just because you have to give the reasons. Whom he will give reasons? He will obviously give reason to the authorization officer. The authorization officer has been given reasons that yes, we are doing it search at 9 PM due to this reason. And the authorization letter was issued. Yes, you are entitled to do it. I have no case. But if you are given an authorization letter, you should do it in the morning. Why you are doing it at night? You are already in custody. So it's a thing which requires your lordship, the balance to be looked into, because why the words have been used? If at all it was just an authorization letter, no, you are authorized, we have issued an authorization letter, you can do it anytime.
No, which other regarding sunset and sunrise? Which
This
other
was the judgment I have put it, and one more, your lordship, that was quoted, Bhutta Singh.
That also
That was with 42, whether 42 is mandatory or not, basically. And in the case, it has mentioned in para 10, Karnail Singh. Karnail Singh is a constitution bench judgment, wherein this has been quoted. You know, and ultimately non-compliance is said to be fatal. Here it is not specific with regard to night and day. Then, your lordship, one more thing I would like to point out with regard to the other case, the Punjab case. No, the Maharashtra case, your lordship. Maharashtra have given one case. That is also given, your lordship. This is the recent matter in para 7 and 9. The applicant seeks bail interiorly on the ground of breach of section 42. The provisions deal with the power of entry, search, seizure, and arrest without warrant or authorization. The scope of so and so has been discussed. I have already, Jagraj Singh and Butta Singh, I have already placed you. The apex court has observed in 42 indicates that any authorized officer can carry out search between sunrise and sunset without warrant or authorization. The scheme indicates that in the event that search has to be made between sunrise and sunset, the warrant would be necessary unless the officer has reason to believe that a search warrant authorization cannot be obtained without affording opportunity to the offender to escape, and the grounds of belief have to be recorded.
Where it has to be recorded?
That has to be recorded, I think, either to the authorization officer or
in
whom
the
I don't
case.
know. It is not been given. This is actually quoting from the section, you know.
Or in the case diary.
Then maybe in the case diary, it should be in the case diary anyway. Everything is there in the case diary. Then your lordship will see in the para 9, same judgment. Next page. Para 9 of the same judgment, your lordship. In the instant case, it is not disputed that the house of the applicant was searched and ganja was seized between sunset and sunrise without warrant or authorization, and there was no compliance of section 42 of the NDPS Act. It is sought to be projected that it was a sun seizure and hence compliance with section 42 was not possible. In this regard, this is not same here, your lordship. In this regard, it is relevant to note that the accused one so and so who allegedly found possession of 2 bags so and so ganja made a disclosure that he is willing to show the place when a person who has purchased the contraband and that person to the disclosure 10 kgs of ganja was recovered so and so. The accused number 2 allegedly made a disclosed statement and he has purchased the contraband from so and so. Pursuant to the said disclosure statement, the NCB team proceeded to the house of the applicant at Ahmednagar and allegedly recovered 50 kgs of gaza for his residence. The material on record revealed that the co-accused had disclosed the name of the applicant as well as address. Hence, prima facie, it is not a case of sans recovery or seizure in the normal course of investigation, but it was on the basis of specific information given by the co-accused. It is also pertinent to note that the said information was given at 3 p.m. and the search and seizure was conducted after sunset. It is not the case of the prosecution that the empowered officer did not have sufficient time to obtain warrant or authorization without affording opportunity to the applicant to escape or conceal evidence. This part will not applicable because he is already arrested. The concerned officer has not recorded reason for such belief in terms of proviso to section 42(1). Hence, prima facie, the search and seizure, which is in contravention of the mandatory provision of section 42 of the NDPS Act, prima facie makes the recovery. So this part is there. Then 37, your lordship, on that day, that judgment I have not given. I am handing over that judgment with regard to 37. I head it to the Supreme Court of it. This is the Supreme Court judgment, your lordship. Sariza Banu, this is reported in 2004 12 SCC 266. At the top it is there. I'll read para 6 and 7. The fact that such a telegram was sent and received is not disputed. However, it is stated by the respondent that they could not find whereabouts of so and so. It is pertinent to note that even though such a serious information was received by police as per complaint, no case was registered and investigation started. From these facts, it appears that something happened on so and so, and these are relevant factors from granting bail. We are conscious of stringent provisions contained in section 37 of the NDPS Act, and we are also conscious of the fact that the charge has now been framed against the appellant and they have to face the trial. It is pertinent to know that in the bail application, the applicants, it was alleged that there was serious violation of section 42 of the NDPS. In the impugn order, nothing is stated about the alleged violation of section 42, and it is observed that it was not necessary to consider such violation at this stage. The compliance of section 42 is mandatory, and that is a relevant fact which should have engaged attention of the court while considering the bail application. In the aforesaid circumstances, having regard to special facts of the case, we direct the appellants to be released on bail, executing a bond of 750.
This is reported in
This
2000.
is reported at the top. Your lordship will see 2004 12 SCC 266. Equivalent citations it has shown. There are two citations, 2004 12 SCC 266. And subsequent to that, your lordship, the Punjab and Haryana High Court have in 2022, following this judgment, and the High Court of Rajasthan and Punjab has also passed judgments following this. I have also got these copies. This is Gujrant Singh from Rajasthan. Odisha to Delhi. Time. Here also, your lordship, the first judgment that I'm taking is with regard to the Rajasthan High Court. This is 19/8/2023, Ashok versus Mundaram versus State of Rajasthan. Here, your lordship will take up para 17 at page 10. Just two paragraphs. It has also considered all these judgments. I'm not reading those. This part only. In the light of the judgments cited above, the notification. Para 17, penultimate page.
Yes.
In light of the other judgments have been considered, all these judgments that I have given have been considered. In the light of the judgment cited above, the notification passed by the state government in this regard, as well as the provision contained in section 42 of NDPS Act. This court is of the view that non-compliance of mandatory provisions of the NDPS Act has to be dealt with strict hand and is imperative upon the courts to be cautious while adjudicating such matters, while seizure is concerned under the NDPS Act, and no accused should be able to walk scot-free for want of proper implementation and following the procedure of law. Para 18. The life and liberty of an individual is so sacrosanct that it cannot be allowed to be interfered with except under the authority of law. It is a principle which has been recognized and applied in all civilized countries. In our constitution, Article 21 guarantees protection of life and personal liberty, not only to citizens of India, but also to foreigners. Para 19, your lordship, here it is mentioned. This court is cognizant of the provision contained in section 37 of the NDPS Act, but considering the submissions made by the Land Council for the accused petitioner regarding non-compliance of the statutory procedure, this court is of the opinion that it is a fit case for grant of bail to the accused petitioner. Needless to say, none of the observations made herein shall affect the rights either parties during trial. So, only on the point that there is a violation of section 42, this has been given. Then there is another judgment with regard to the Odisha. This was on 14/10/2022. This is a long judgment. I'll just refer to two paragraphs. Paragraph 22 and 23. Here, your lordship, two parts is there. The first part is with regard to both 42 and 43 has been not been complied with. Para 22 and 23. Same thing has been stated here also, your lordship. It's mandatory, and in such a ground, section 37 on the NDPS Act would not be attracted. So that part on. For that reason only I have brought this here. So at para 22 last line. Therefore, this court is the not last line, at least 5 lines on this paragraph. Therefore, this court has no hesitation to hold that if prima facie from record FIR, it can be established that section 14 to 50 of the NPA, which is mandatory in nature, has not been complied with. The court, considering the bail application, can always use the same as a ground to analyze the petition on bail. And in such event, the power contained under section 37 of NDPS Act would not be attracted to the facts of the case. So this point I am coming with this. Then there is one more judgment, Your Lordship, that is with regard to the Punjab. This was on June. This is Pankaj. No, Pankaj ekhon diya nahi. Pankaj kon diya nahi. Pankaj ko disa na. Or Gujran Singh. Who is Pankaj to be? Pankaj was a state of Punjab. This is Pankaj versus State of Punjab, 14th of June 2022. Here, I will take Your Lordship straight to page 18. Lordship, page 18. Paragraphs are not very consistent because other paragraphs are also quoted in between. So, I am taking Your Lordship to page 18. There in paragraph 25. Here, I am taking Your Lordship to 25 to the ground to show that the case of Bhutta Singh, which I have referred, has been considered by this Honorable Court. And then Your Lordship will kindly turn to page 21. 21, Your Lordship will see para 12. The Honorable Supreme Court and various high courts have granted the concession of bail where the mandatory provisions of NDPS Act have not been complied, and even where the recovery is of commercial quantity. The contraventions of the judgment in this regard are reproduced herein below. First judgment that here it has been shown is that of 2004 12 SCC 266. That is what the Sariza Banu that I have already given to Your Lordship. Here it has quoted that. I am not reading therefore. Then in the next page, the Gujran Singh versus State of Punjab. Here also it has stated that mandatory provisions of the Act. At next page, the first part, I have the copy of Gujran Singh also. I'll just forward you. Once the mandatory provisions of the Act has been found to be prima facie violated, the rigors of 37 of NDPS would be relaxed. So these are the judgments only on the point that if there is a violation, then it will be relaxed. So that is only part. And with regard to whether the authority, whether the IO will have to record his reason prior to taking the permission, that is the statutory part. Because as part of the statute, an authority can be given. And I think he has also said that there is an authority letter where he must have disclosed that he is going to do the raid or seizure at a particular place at a particular time at night due to this. If that is there, then they have complied with. If that is not there, then they have not complied with. That is my case. That much.
Given so many that.
Now, whether proviso of section 42, as has been contemplated by my learned friend, will be applicable in this case or not?
Yes.
That has to be ascertained from the facts of the case.
Yes.
Which law will be applied? So therefore, my lord, with all respect, I submit, we have to clear first the facts of the case. Now, I beg to draw your lordship's attention to the GD entry in respect of, my lord, in respect of information received, secret information received. That is GD entry number 769/22, dated 26/12/2022. That's right. This GD entry was recorded at 5 p.m. Now it reads as follows. I am reading it for your lordships and also for my learned friend.
It is there in the record.
It is there in the record.
Flag it.
Yes, I have flagged it. GDE 769. No? Now, should I read it?
Yes.
এতিয়া মাননীয় এডিচিপি চেন্ট্ৰেল মহোদয়ে ফোন যোগে জনায় যে তেওঁ গোপনীয় সূত্ৰে জানিব পাৰিছে যে পল্টন বজাৰ থানা এলেকাৰ লগতে সমগ্ৰ গুৱাহাটী মহানগৰীত AS01EH9902 নম্বৰৰ বগা ৰঙৰ এল্টো গাড়ী এখনেৰে দুৰ্বৃত্তই ড্ৰাগছৰ অবৈধভাৱে বেহা চলাই আছে। গতিকে উক্ত গাড়ীখন সহ দুৰ্বৃত্তক কৰায়ত্ব কৰি বিহিত ব্যৱস্থা লোৱাৰ বাবে নিৰ্দেশ দিয়াত পঞ্জীত দৰজ দি লগে লগে WSTP জিতুমণি ৰাভা আৰু সংঘীয় ষ্টাফক মোতায়েন কৰা হ'ল। That means the team was formed for it. Then, my lord, next GD entry. This was recorded at 5 minutes past 5 p.m. That means after first GD entry, next GD entry is after 5 minutes. What it reads? এতিয়া মই মাননীয় এডিচিপি মহোদয়ে প্ৰেৰণ কৰা অথৰিটি লেটাৰ থানাৰ চিৰস্তাদাৰৰ পৰা এখন দগাপাল্লা আৰু সংঘীয় ষ্টাফসহ দুৰ্বৃত্তক অনুসন্ধানৰ বাবে পল্টন বজাৰ নেপালী মন্দিৰ অভিমুখে ৰাওনা হলো। He moved out of police station along with the authority letter and that measurement, way measurement, Tagapalla. Way measurement apparatus, my lord.
That
So
authority letter-
already, that means already they were issued authority letter.
No, for what purpose? That
For
author-
this, as per this GD entry,
No, that authority was for what purpose?
is that authority letter must be in the Milord Malkhana. That is not available in the record.
No, but for what purpose that authority was issued?
Yes, that can be seen, Milord, that has to be called for authority letter. Because this,
Because their submission is the search in the house was after the accused was arrested. After the accused was arrested, he disclosed that he leaded them to the house. So at that time, they were not knowing where the search was to be made, whether it is to be made after sunset or not, whether these things are, because what is,
For that purpose, we have to look into Milord the authority letter. The authority letter is not available. It must be in the Milord Malkhana. Because this is supposed to be an exhibit.
you produce that authority letter.
But that has to be called from a trial court, Milord. Cases can you?
No, but
succeed at level.
their submission is that authority to conduct search during night was not there.
Yes, contents, we do not know what is the contents of that authority letter, but authority letter is there. We do
Your
not know what is the
submission
content.
That authority letter may also be for search during night also. It may happen. That is unlikely.
Yeah, there, your lordship will kindly note one thing, Milord, this is a December month. The month is December. By 5 p.m, Milord, there is sunset, I suppose. Yes.
So what is your submission?
So, to ascertain the contents of the Milord authority letter, to what extent he was permitted to Milord search,
You
conduct
produce
search,
that authority letter.
that is to be called from the trial court,
I
Milord.
will
This-
see if authority letter is there, their case has, they
Yes,
don't
yes,
have a
yes.
case.
Just a moment, if your lordship. What my learned friend read from the first
GD
and
entry.
second GD entry. First is
It was even
connected
before
with the
apprehension.
second. The first one says that we have received information
Information.
that somebody is going to raise.
Information was recorded down in writing.
Yes, there was nothing there except the information that X person was
No,
moving
the
around
vehicle number is
in a
there.
vehicle.
Vehicle
No, no,
number.
no, vehicle, quick.
Vehicle number.
Somebody was moving in a vehicle, was dealing with drugs. And so they were authorized, a team was formed to do the whatever is required to apprehend him. It is not a authority letter to go and search the place. Second was that team was given the authority letter for what authority letter? So the first GD entry authority has been given in the second one because there was nothing in the to show that we are actually going for a search at a particular premises. Premises 42 will come, otherwise 43 will come. So that part, your lordship, will have to be verified. So if you are in a premises 42, if you are bodily search, separate. So that is why I am saying that.
Because it has to be there in the case diary that there was a necessity of search of the
Yes.
premises.
What
And
they,
we searched the premises
Yes.
without under so and so circumstance.
my case is that, basically. They have stated that yes, we are finding a person moving around in a vehicle. So you go and apprehend him. So authority has been given on that. That is the basic, my case. According to them, if the authority says that you also are authorized to do the search at night, then I don't have a case, that much. Only the authority letter, let them produce and then.
No, authority letter, obviously, it is related to first 769 GD entry.
So, okay, what is your
So,
submission?
no, my lord, if your lordships for forming any satisfaction in respect of contents of the my lord authority letter, then it may be called for my lord.
From,
Because regarding contents of the authority letter, there is no entry in the case diary. Contents are not there. So, my lord, learned, it may be called for from the trial court. Yes, yeah. Scan copy.
no, it is your submission that authority letter is there.
No, no, it is not my, this is, it is revealed from the case diary, ZD entry. I'm making my submissions on the basis of record.
That GD entry number is?
ZD entry number is 769/22 dated 26/12/22.
That was the first entry.
First ZD entry regarding information.
Next,
Next, same ZD entry, my lord, at 5 minutes past 5 PM. Pasta pas bajar. And pasta 10 বজাত তেওঁ নেপালী মন্দিৰত হেৰি আহি উপস্থিত হয় 5টা 5 বজাত তেওঁ ৰাওনা হয় he moved out of the police station and then at 5:10 he arrived the
but
spot.
by that time, they don't know where to conduct the search. At that time, they were not knowing,
They were knowing because vehicle number is there.
but search is not of the vehicle. Search is of the
House.
house.
Yes. Yes, that is why let the contents of the authority to what extent he was permitted. Let the because on being arrested, he was seized. Thereafter, he was arrested, and on being arrested, on being interrogated, he took them to his house.
You produce the authority letter. Let us see the authority letter. Yes, Mr. Manan, what is your submission?
I have nothing to say. They
Then
want
they-
that the authority letter should come. My case is very simple. From
No,
the-
no, that I have understood.
Your lordship has appreciated.
then
Now,
we-
the authority letter is for the party to go and apprehend the person. This is not an authority for search and seizure. That's my submission.
But let us see.
That's only.
Heard Mr. Y.S. Manan.
And the team was, my lord, headed by Additional Deputy Commissioner of Police. Gazette officer was also there. Anyway, my lord, let
Heard Mr. Y.S. Manan.
come to my lord,
Learned
reasonable
counsel for the
conclusion.
petitioner. Also heard Mr. D. Das, learned D. Das as well as Mr.
K.K.
K.
Parashar.
Parashar, learned counsel for learned additional public prosecutor. Learned counsel for the petitioner has submitted that in this case, the search and seizure was conducted after sunset and before sunrise. And no authorization, and the mandate of section 42, mandate of second proviso to section 42 clause 1 has not been followed. in the instant case, as there is nothing to show that the search and seizure was conducted after obtaining search warrant or authorization for the said search. And there is also nothing to show that any reasons were recorded by the seizing authority to show the grounds of his belief that the seizing officer has reason to believe that search warrant or authorization cannot be obtained without affording opportunity for concealment of evidence or for facility to escape the offender. On the other hand, learned additional public prosecutor has, from the scanned copy of the case record which was called for, submitted that the investigating officer has made a GD entry number 769/2022 at 5:05 PM, wherein it has been mentioned that authority, what has been mentioned? What has been mentioned? Authority letter has been issued.
Yes, yes. As it appears from the
5 PM and
5,
That authorization letter has been issued
at 5 minutes past 5 PM.
in this case. Stop. In view of the submissions made by learned counsel for the learned additional public prosecutor, as well as submissions made by learned counsel for the petitioner, it appears that perusal of the said authorization letter would be necessary to appreciate the submissions made by learned counsel for the petitioner as to whether there was any compliance of section 42 of the NDPS Act 1985 in this case or not. Hence, from where we will call,
Well, from trial court.
hence,
Evidence recently.
let a copy of the
Scan copy. only.
let a scan copy of the authority letter as mentioned in GD entry number 769/2022 at 5:05.
This is second GD entry number 2.
Five.
That item.
5:05 PM
Five.
be called for from the learned trial court.
Dated 26/12.
Dated GT number 769/2022 at 5:05 PM dated 26/12/22 be called for from learned trial court. Let this case be listed again on
Issue. PTI.
It's up to them because
Itu
how,
moi nanu no. Registry anyway.
your lordship, as early as possible, I will just make.
After view vacation.
20.
20 is, I think, a holiday.
No, difficult.
20 is like a bondas.
This then. 22nd.
23rd February. 23rd
January.
January. The registry shall take steps for requisitioning the scan copy of the GD entry as directed herein above. Let this case be listed accordingly.
Yes.
My lord, before lordship, your lordship is taking up, no, wait, no, taking up item number 59. my lord. I have to mention one thing, my lord, in respect of, order has already been passed in respect of item number 24. my lord.
No, just a moment, if your lordship, this matter, since I have already argued before your lordship, can it be kept as part?
Yes, let this matter be listed on so and so as a part heard matter.
Much.
Yes, ঠিক আছে।
Yes, please.
Item number 24. My lord, earlier I received some wrong information from the IO. Well, I was told that this petitioner of item number 24
has filed a petition.
petition before. Now again, he has confirmed that his name is not there, other 3 persons are there. So my lord, calling for report, that person may be my lord, expunged my lord, from that order.
Item number 24, that second portion delete code.
Yes,
I will
the
delete it.
calling for report portion may be. I'm sorry, my lord, sorry for causing the inconvenience. Well, sometimes it is difficult to make submission on the basis of
No,
telephonic
no,
instruction.
No issue, no issue.
May please your lordship, in this case, LCR call for has not been received, lordship. Can a reminder may be issued, lordship?
Heard Mr. P.
P.
Desai,
Bordwell.
P. Bordale, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. It appears from the office note dated 4/1/2023 that the scan copy of the case record as well as case diary, which was called for, has not yet been received. Registry to issue reminder for requisitioning the scan copy again. Let this case be listed.
Can it be on 11th, lordship? 11th or 12th?
11 would be too short. After before.
Then lordship, and 19th, lordship, or 18th, lordship?
Let this case be listed again on 19th for scan copy of the case record and case diary.
Lordship. Oblige, your lordship.
Well, on third, my lord, CD was called for today's second date, ma'am, for calling for a case there, my lord. 439 application, my lord, the petitioner behind the bar, my lord, since last 30 days, my lord. Today is 30 days, my lord.
CD is not there.
Not there, my lord. From Satgaon, my lord, very unfortunate, my lord.
When will you bring? CD would be required.
Now, can you see the FIR, my lord, allegation, my lord, the informant tried to, from the first day I have received, my lord, tried to give the civil suit to a criminal offense, my lord. But the informant, my lord, entered into agreement, my lord, deed of agreement, my lord, sale agreement with the, my lord, accused petitioner, my lord, to purchase the plot of land. And
No, but when once court has taken a view that case diary would be necessary,
Short date, lordship.
now the police did not comply with the court order, my lord.
we'll fix a short date.
On 11, lordship.
On Monday, my lord.
You
11
have to
I
ensure.
on Monday, my lord, from Satgaon, my lord.
Monday, my
No,
request
but they may not be able to communicate because vacations are there tomorrow, day after, on Tuesday.
Tuesday, my lord.
lordship, 9, lordship.
Heard Mr. S. Bhattakur, learned counsel for the petitioner, also heard Mr. P. S. Locker, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Learned additional public prosecutor shall ensure the production of the case diary without fail on the next date fixed.
Publish.
Let your 439 application lordship. FIR your lordship will find page 14. Here in this case, my truck was apprehended along with the driver and handyman lordship. And from the vehicle lordship, some contraband was recovered, ganja was recovered. And they both the persons were arrested. And accordingly, this present FIR was lodged. And after arrest lordship, that seizure was made. Seizure list your lordship will find page 17. I am not named in the FIR. My name is not there, only that I am the owner, registered owner of the vehicle. There. Page 17, your lordship will find the seizure list. Page 17, lordship may only see the in top portion, seizure list, then GD entry number and dated lordship may only note that 11/11/2022. Seizure list. And then the lordship may kindly see column number 3. That after that calculation, that column number 3 is there. One Xerox copy of registration, where your lordship got it.
Yes.
In fourth line, owner name Abul Kasem. They know my name on 11/11/2022. For that purpose, I am showing this seizure list. And now lordship may kindly see that after my vehicle was apprehended, I filed Zimma petition before the learned court below. That your lordship will find page 19. I have no apprehension, so I have never filed any bail application. Nothing has been, no bail application was filed by me, lordship. That page 90, your lordship will find that after filing Zimma application, what IO has reported in serial, in paragraph 3, your lordship will find, IO has reported to the effect that the vehicle is required for further for investigation and its ownership could not also be ascertained as yet. And this order, lordship may kindly see that 12/1/2023. On 11/11, they already got that registration, my registration certificate. They know my name, but yet they are not disclosing. And thereafter, lordship may kindly see page 20. There was a direction by the learned trial court to appear before the IO to produce all the relevant documents on 10/2/2023. Page 20, your lordship will find.
Yes.
In first paragraph, the IO again said that he could not find the actual order. Then in second column, your lordship will find, in view of the report being received, the aforesaid petitioner shall produce all the relevant documents in support of his claim towards the ownership of the aforesaid seized vehicle before the IO, who shall accordingly send the report on the basis of the documents submitted. Fixed on 6/3. So thereafter, because of this direction, I appeared before him and I was taken into custody. This is the case. And if your lordship see the statement of these two persons who were initially apprehended, they did not name me. I appeared there. My statement was recorded. In my statement also, no confession is there. Only merely that I am, because of the reason that I am the owner of the that vehicle, I was put behind the bar. So initially they filed one charge sheet that your lordship will find page 21. This is on 28/2/2023.
PDP হয়েছে নাকি? এটা মানে না? PDP হয় না এটা?
Lordship, this charge sheet was submitted on February 28/2023 against the two apprehended persons. And now lordship may kindly see page 31.
No, in this charge sheet, your name was not there.
My name was mentioned, therefore I am referring to page 31. Not as an accused, as a registered owner. Page 31. In bold lordship, they have said that they made some communication to me to appear before them on 23rd February 2023 under section 67. Yeah, I am referring to this because lordship, subsequent in supplementary charge sheet, your lordship will find in terms of that communication, I appeared before them. And here in this charge sheet, only that after those bold words, your lordship will find, however, on the basis of FSL report, lordship got it?
Yes.
Statements of witnesses and other evidence, the prima facie is well established that arrested accused person, namely Sujan Mia, so-and-so, Amdadul Haq, so-and-so, is fully involved in the activities of trafficking and smuggling illegal narcotic drugs from Tripura to other states of India. Therefore, I pray before the Honorable Court to kindly prosecute the aforesaid accused person under section 2. So it is against them. And now, lordship, however, this charge sheet may be treated as part in nature and a supplementary charge sheet along with SCD. Supplementary case diary shall be submitted to the Honorable Court once the statement of the actual owner has been recorded. So my involvement only that much, that my statement is required there. So after receiving the notice, lordship, from the investigating officer, I appeared and accordingly I was apprehended. Now, lordship may kindly turn to page 38. This is the supplementary charge sheet. In bold portion, your lordship will find the same communication numbers, that is dated 10/2/23, 23/2/23. Those are there. So I am not on that, lordship. After those bold words, your lordship will find on 5/4/2023. Lordship got it?
Yes.
The owner of the vehicle, namely Abul Qasem, so-and-so, came to PS, recorded his statement, and he was found suspected to be accused person in connection with the above referred case. So he was only suspected. It is not their case that material was found against me.
Okay.
And even if your record is there, your lordship can peruse the statements of those two apprehended persons. They did not name me, Lordship. They said they on instruction of someone else, they carried those articles. And
Who are
really,
they? They are the driver.
they are driver and handyman. I am the registered owner of the vehicle.
Now, in supplementary charge sheet, what else was there?
Only suspicion, that's all.
Suspected.
Only that much. And even if your Lordship reads next sentence, your Lordship will find that on the basis of, Lordship got it, that
Yes, yes.
on the basis of FSL report, I am not disputing that. MBI report, I am registered owner, I have filed Jimma petition, I am not disputing that. Vehicle report from Bahan Samawai, Karimganj, Assam. The prima facie case is well established against the arrested person, namely Abul Qasim. How it is well established? That is the question, because I am the registered, I am not disputing that. So this is only that
This case,
suspicion.
Mr. Raj Didas has gone through this record, Lordship, and he is now going to attend another court, Lordship.
Whether materials are there.
Okay, your Lordship.
Our CD and scan copies.
Yes, the LCR is here.
LCR is here, Lordship. Can be taken on Monday, Lordship.
Heard. Mr. A. Ahmed, Learned Counsel for the petitioner, also heard. Mr. P. S. Lockhart, Learned Additional Public Prosecutor.
Monday is going.
Though the counsel for the petitioner has made his submissions, however, Learned Additional Public Prosecutor has submitted that this case is being handled by Mr. D. Das, Learned Additional Public Prosecutor, who is on legs in some other court, and therefore he prays for fixing this case on 8th of January, so that the reply from the state, reply to the submissions made by Learned Counsel for the petitioner may be given. The prayer is allowed. Let this case be listed on 8th as part admit.
Obliged.
May please your Lordship, when item 30, my lord, the council has left because of some personal difficulties.
Yes, CS file, Lordship.
And he told me that he was in interim, my lord.
CS file, Lordship. CS file, Lordship.
Whether the petitioner has cooperated in the investigation.
Lordship, CS file, Lordship, only.
Yes, we may make the interim absolutely if they have cooperated.
See that we cannot say no, Lordship, because CD we have not gone through, Lordship.
They may make the submission.
Mercifully, if it can be taken up Monday, my lord, conducting council.
He is not the conducting.
I'm not the
Okay.
conducting.
Let us take it up. Heard Mr. M. A. Ahmed,
M.A. Chaudhary, my lord.
M. A. Chaudhary,
IH.
Learned Counsel for the petitioner submitting on
I-
behalf
I'm on
of,
behalf of Mr. I.H. Lashkar, conducting
who
council.
is submitting on behalf of I.H. Laskar and prays for an adjournment on the ground of personal difficulties of the conducting counsel. The prayer is allowed. Let this case be listed on 8th of January 2020.
Till then, interim will continue. my lord.
The interim order shall continue till
Declare.
next day.
May I please your Lordship? Here in this case, Lordship, I am on interim Lordship. City was called for Lordship. As per the direction of this honorable court, Lordship, I appeared before the IO and the statement has been recorded, Lordship.
As per CD, Lordship, the co-accused person, Lordship, the main accused person, Nikhil, Lordship, he has implicated him that he used to make for fake PAN card, Aadhaar card, all these, etc., all these cards through this person, this petition, this accused person. This accused person used to prepare all these things, and they, with the help of this, they used to cheat other person, Lordship. They took money from other person, they are showing some others land, Lordship. Land giving, this is mainly, Lordship.
Now, whether he has appeared,
He appeared, Lordship, but
statement recorded,
Statement has been recorded.
whether you require his custodial.
Lordship, because Lordship, nowadays, Lordship, this is the main case where so many cases are registered in this case.
We'll direct him to appear before you.
He has appeared, Lordship. but
Again, if
Lordship-
you want his if you want his further interrogation,
Lordship-
he may be directed to appear.
But Lordship, yes, he has stated here, his statement has been recorded and he has denied, Lordship. And there are some other judgments also, Lordship, on Apex Court, Lordship. Today I am not available with that, Lordship. That when person is escorted with with an interim order, so he never discloses anything, Lordship. So, Lordship, here in this case, Lordship, his interrogation is required, Lordship.
No, you interrogate him, but
But again, Lordship, he will say same thing, Lordship, because he is the under protection of interim order, Lordship. He will be. He will never disclose. But Lordship, the main accused person has stated, Lordship, that how they used to cheat other person, Lordship. 49 lakhs rupees has been taken from other person. Lordship.
All the amount, Lordship, transmitted in the account of Mitul Das, Lordship, the prime accused, Lordship, the named FIR of the accused, Lordship. 7 pages FIR, Lordship. I am not implicated in any line, Lordship, any single line, Lordship. And
no, Mr. Locker, if you want his interrogation, we may direct him to appear before the IO on regular basis, weekly or daily or after 2 days. But when he has appeared before you in person to the directions of this court, whether his custodial detention,
He will cooperate with the investigation and, Lordship,
okay, heard Mr. M. Bishwas. A. Barwal, learned counsel for the petitioner. Also heard Mr. K.K. P.S. Lalkar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was allowed to go on interim anticipatory bail by this court by order dated 21/11/2023. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Jagirod PS case number 300/2023 and has submitted that though the petitioner has appeared before the investigating officer and his statement under section 161 CRPC has been recorded. However, it appears from the endorsement of the IO in the case diary that the petitioner is not cooperating in the investigation as has not disclosed the true facts to the petitioner, and his further interrogation is necessary for fair completion of the investigation. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record, including the case diary of Jagirod PS case number 300/2023. It appears that the statement of the petitioner has been recorded under section 161 CRPC. It also appears that the co-accused has implicated the present petitioner regarding his involvement in the offense alleged in the FIR. Hence, further interrogation may be necessary. However, as the petitioner has cooperated in investigation and has appeared before the IO in pursuant to the directions of this court, his custodial interrogation may not be necessary if he otherwise appears before the investigating officer and cooperate in the investigation. Therefore,
that's with satisfaction of the IROs.
in view of above, the interim bail granted to the petitioner by order dated 21/11/2023 is hereby made absolute with an observation that the petitioner shall appear before the investigating officer every week for next 4 weeks or till the investigation is completed, whichever is earlier. And he shall appear before the investigating officer as and when so required for the sake of fair completion of the investigation of this case. In addition to the above condition, the condition number 2 and 3 attached to the interim anticipatory bail order shall also remain intact. With above observation, this anticipatory bail application is hereby disposed of.
No, sir.
My lord, I beg to mention item, my lord, 42. My lord, the interim order is still today, my lord. Otherwise, the case is fixed on 17/1. So may I pray, my lord, the interim order may be extended till the next date and lordship fix a date.
Item number?
Item 42, my lord.
Item
Lordship, I am appearing as a special PP in this particular case, and his submissions may kindly be recorded.
Actually, my lord, service report is not complete, my
Yes,
lord.
maybe.
And the LCR has, a scanned copy of the LCR has also not been received. So lordship will fix a date, and till then, my lord, the order may continue.
This case could not be taken up for hearing due to paucity of time. The interim order granted earlier shall continue till next date.
Lordship,
Let this case be listed again on
date at again.
24.
Item, my lord,
17 is-
excuse.
24.
My lord, instead of 24, there is some function in my house. Can it be after any date after 7th of February?
17, the earlier order was only for exemption on 3rd of
No,
3rd of
next
January.
It is fixed
3rd
on
of-
17, that's why.
That the same order may kindly be passed so
Okay,
far as the
huh.
exemption is there.
Okay.
Only
Well,
the personal exemption is there.
My appearance on 17 may be exempted.
That may kindly be
Yes.
taken on record, and my
Okay,
name,
that will do, yes.
my name may kindly
My
be shown.
learned friend is correct.
The learned senior counsel for the petitioner as well as learned special PP submits that the earlier order passed by this court. Earlier order was on
Earlier order was on, my lord, 22/12/23, whereby my appearance on 3/1 was dispensed with.
by order dated 22/12/2023. The appearance of the petitioner before the learned trial court was dispensed with
3/1/24 was dispensed with.
for 3/1/2023.
24.
24. However, as the next date of the case before learned trial court is fixed on
17.
17/1/2024. On the basis of the submissions made by learned counsel for both the sides, the personal appearance of the petitioner
On
before the
17.
trial court on 17/1/2024 shall also be dispensed with.
Your Lordship may kindly record that since the LCRs have not received, because I have made submission on that basis.
Okay. Issue. I'll make corrections.
Yes.
Issue reminder for the LCR.
Yes.
LCRs.
Let this case be listed on
That.
7th,
After 7, my lord, 9th of February.
By the
9th of February.
after 17. My name may kindly be shown on.
What is
Mr.
the-
J. Hassan.
Mr. J.
J. A. Hassan.
J. A. Hassan.
Special PP in this case.
Item 40, today's
Hello.
item 40, my lord, orders.
Item,
Item 40 orders, my lord, today's. My lord, this is a case pertaining to the stay and bail during pregnancy of the appeal, my lord. Appeal was admitted on 25/9. Now this interim application is pending, my lord, for bail and stay. So my prayer, my lord, is to witness if your lordship so pleased to select, my lord. Or the 10th January, 10th month.
then court master will have to help us.
Made visual.
For all
10th.
all other matters which could not be taken up for paucity of time, court master will give dates.
So,
You take
Lordship,
dates.
I have a prayer, Lordship. In item 65, my senior is supposed to argue this case. So can it be fixed on 11th, Lordship? Mr. H.R. Chaudhary will appear,
It
Lordship.
is subject to the availability. Otherwise, on 11th, same scenario will occur.
Lordship.
How?
If
Court master
possible,
will-
Lordship, if possible, say, anticipatory bail, your Lordship has called for the scan copy.
He will
Lordship.
accommodate everybody subject to our board. And wherever there is interim order shall come.
Lordship, scan copy has also not received, Lordship, so registry may be kindly.
In item number?
65, Lordship.
In item number 65, the registry to issue reminder for
Scan copy of the.
requisitioning the scan copy. And let this matter be listed on
11.
11-1.
I'm deeply obliged.
And
But date has been given in the middle. In item 14, my lord.
which date you want?
Given,
When you want?
My
No,
lord,
10-1.
I'm sorry, my lord, because item 46, my lord, very urgent, my lord. Because only for extension the time I have filed, my lord. The honorable directed, my lord, within the month, he could not appear, my lord. So kindly, maybe, my lord, the date may be fixed. Already.
No,
it is-
date will be given by the,
My lord,
court
if
master.
possible, my lord, 8 or 9, my lord.
we have to see our board. That is not before me. Anything?
My lord, my item was 12, my lord, for admission. The criminal revision, it was a NI Act case. my lord. And the next date for remaining cross examination before the trial court, my lord, on 19 January, my lord. So my humble submission, my lord, the trial court has suspended the further proceeding, my lord, going to pendency of this case before this honorable high court, my lord. So the short date may be given before 19 January, my lord.
My lord,
Court master.
my lord, in item number 61, my lord, charge sheet has been submitted, my lord.
Charge sheet number, lordship. 259.
61. You
61.
are on
Yes,
interview.
my lord, yes.
61, you have cooperated.
Yes.
61, the order, make the order absolute. Charge sheet number.
259. Dated 30/6/2023.
Okay. With the conditions which were attached earlier, with those conditions, the order is made absolute.
Highly obliged.
259/23, huh? 259 of 20.